item for listing on Friday, on Monday, madam. Motion
matter, yes.
motion matter.
Similar motion.
May I please, Lordship? Lordship, I beg to mention item number 17, Lordship.
On
Supplementary.
7. Supply list.
Supply, Lordship.
Yes.
Lordship, my senior is at the station, Lordship. He's at Delhi now. Difficulty is there, Lordship.
It is connected with the other matters.
Yes, Lordship.
Yes, have you informed the other council?
I have taken the concern, Lordship.
Okay, when do you want?
KSCC is here.
And the other council, K.N. Chaudhary is there?
I am for the item number 19, my lord.
19.
Yeah.
You are with Mr. Chaudhary?
I'm D.K. Bora.
No, no. Are you with Mr. Chaudhary?
Yes, yes.
Your name is not there, Mr. Bora?
Yes, sir. My name is in the Okalodama, but.
Okay, it doesn't matter. If you are informed, okay. A prayer for adjournment has been made on behalf of Sri S. Buragohai.
As per.
As Buragohai, Learned Counsel, for the petitioner in one of these cases. Para. In view of the above, matters are adjourned to be listed.
Lordship, can it be on 31st of this month, Lordship?
21st. 21st is Thursday. We'll have it on 22nd. Motion matters
Lordship.
on 22nd. Okay.
Humbly obliged.
22nd is okay for you, Mr. Bora?
It will be 25, it will be convenient for me.
22nd and 25th. 25th is a holiday.
Yeah. Yeah, 26, my lord.
27th.
My
Okay. 27th.
My lord.
Wednesday.
My lord.
Humbly obliged. Lordship.
May I please, Lordship? I beg to mention item 13, Lordship, on yesterday,
Matter of which year?
for 2022.
Hmm?
We- we have
22. Okay. 22. Yes, what is your?
So in this case, Lordship, we want to some file our affidavit in the amendment petition. So,
You have to file.
Yes.
You have
Taken
informed the
it-
other
yes,
side.
yes. We have to circulating the adjournment slip yesterday.
No, that is okay. Adjournment slip is not the issue.
Mhm.
When will you file? How soon can you file the affidavit?
There's we have some 2 weeks, Lordship, because we want some resolution from the respondent.
There is an amended
Petition,
petition.
petition.
Okay. Sri
Response.
Chetri, your name is not there.
I respondent 10.
Sri A.
11.
Chetri, learned counsel appearing for the respondents 10 and 11 has informed
Yes.
that an amended writ petition has been filed
I am the.
and his clients would like to file an affidavit. Full stop. In view of the above, matter is adjourned by 2 weeks to enable filing of such affidavit.
Obliged.
May it please your lordship, beg to mention listing of a writ petition, any date list coming.
Writ petition what? For what?
Motion matter,
Motion, no problem.
any date.
Yes, yes. Don't give a motion day. Monday, Tuesday, Monday, Wednesday, Friday.
Obliged.
Wait, please, your lordship. Lord, may I pray for an urgent matter to be listed today, my lord? It's an eviction matter, my lord.
Today we have to rise early. If you can bring it, what is the urgency?
My lord,
Eviction.
Eviction, my lord. And
Uh,
these are
where?
the people,
Which-
my lord, from
Which place?
my lord, they are the resident of Assam and Arunachal border, my lord. The Moran community people, my lord. And there is an ongoing process of resolution going on to solve the border dispute.
Hmm.
Though, my lord, there has been eviction notice issued by the forest first, saying that they are the residents of Arunachal, my lord.
No, the eviction is because of forest, not because of the state dispute.
No, this village falls within the state of Assam and doesn't fall within the forest, reserve forest of the Arunachal, my lord.
No,
there's
we can try, but bring it.
I'll
We
try.
have to raise
I'll
it.
try. I'll try, my lord.
And inform the forest
Yes,
council that
Yeah.
you are moving unlisted.
grateful.
May I please, Lordship, I beg to mention item number 8, Lordship. Leading counsel, Mr. S. Somebody has some personal difficulties, sir.
8. Okay, when?
Lordship, any date, Lordship.
Other side informed
Yes, Lordship, I have.
Yes, my lord, I am for the respondent number 2.
on a prayer made on behalf of the petitioner. Matter is adjourned to be listed next week. Item number 8.
Lordship,
Any date may be fixed.
Admission matter. What is the matter about?
The land matter.
Now, on request, list on 22nd of August.
Lordship, interim order is there.
22nd of August, interim order passed earlier to continue till the next date of listing.
May it please your lordship, I beg to mention listing of an unlisted matter, my lord, for today itself, my lord, the bank account has been freezed
Today,
today, my lord.
when was the action taken?
Day after yesterday, my lord, evening, day after yesterday.
Day before yesterday.
Yes, my. Day before yesterday.
Okay, we try, but this court will rise early. Bring
My
it.
lord, much obliged.
Against which bank?
Against the Punjab National Bank, my lord.
Do they have a standing counsel? Do they have a standing counsel? I think PNB has Mr. A. Ganguly.
I'll inform my lord. Much obliged.
May I please
Mr. Chaudhary?
My lord, in item number 26, my lord, I file a, my lord, additional affidavit, my lord, to bring some facts, my lord.
May it please your lordship, with the consent of the other side, I beg to mention item number 11, your lordship, and 12.
11, 12 are matters of which year?
Lordship 17.
17 and 18. We are in 2025.
Mine matter is
We don't adjourn matters like this.
Lordship, my senior is not well, your lordship, today.
Who is your senior?
And Havelia.
No, matter kata. 17 matters. Yes, when do we do? Tuesday next, Tuesday.
21st after 21st, Lordship. I agree out of.
Okay, Nalak. Then we'll have it on 26th.
Lordship.
Okay, 26th. A prayer for adjournment has been made on behalf of Miss Anna Havelia, learned counsel for the petitioner who is stated to be unwell. Para. Sri S.C. Kyle, learned senior standing counsel, CGST, has however objected by submitting that the matters are long pending. Para. Considering the above, while adjournment is granted, the matters are directed to be listed on 26th, 26/8 for hearing.
Lordship, same prayer for item number 11, your lordship.
11 and 12.
11, 12.
He is there for 11. 11, you are not there. 11 is state of Assam.
State.
11 to Belik ke likhi do, huh? It matters no better. Anyone for finance department? Finance department? Okay, Hari. B. Chaudhary got it. SC Kalu there. B. Chaudhary, standing counsel, finance section. Okay. We are fixing on 26.
Yes, ma'am.
In this case, Lordship, we have been directed to obtain instructions regarding the demarcation, Lordship. Demarcation is fixed on 21/8. This is the.
Yes,
Can we close this?
yes.
We record his heard Sri R.S. Chauhan, learned counsel for the petitioner who has approached this court with a grievance that his application filed for demarcation of the land has not been acted upon. Full stop, para. This court vied the earlier order dated 37, this court on the earlier occasion, that is 37/2025, had passed the following order, court para. Pursuant to the aforesaid direction, Sri H. Sharma, learned additional senior court advocate Assam, has submitted that written instructions dated 13/8/2025 has been received, as per which the date for demarcation has been fixed on 21/8/2025. Full stop, para. From the aforesaid communication, it appears that the grievance of the petitioner has been substantially redressed. Para. In view of the above, writ petition is closed. Written instructions dated 13/8/2025 issued by the circle officer, Puragaon Revenue Circle, is made part of the records.
Obliged.
Yeah.
Yes,
Lord, I have received instruction from my client that, my lord, if the inspection is done at the instance of the original landowner or by authorized representative, because here in this case, writ petitioner is not the neither authorized representative nor the original owner. So in his presence, let writ petitioner be present. I have no objection, but the original owner or by his
who is the
authorized-
original owner?
Sanjay Kumar Dam, his brother. elder brother.
All throughout the litigations, my lord, he was represented by the power of attorney holder, the writ petitioner. It
So
had
if
flowed,
he is the power of
it
attorney
had
holder, then
flowed all.
No power.
There's
That
a
is
power of
why-
attorney holder, page 57, my lord.
If he produces,
57.
then no problem.
57,
He
57.
produced
Page
with the
56.
power of attorney.
page
We have
57,
no-
my lord.
57,
57, 81,
57.
57, my lord.
No, not 57. So,
57,
Huh?
towards the last part, my lord. In the early round, my lord. Schedule, so and so, Sanjay Kumar Dam, brother of the applicant, who had the,
no, let us see the power of attorney.
we have not enclosed here because all
Bring
through.
the power, of- since they are disputing this.
Let the elder brother be present, no problem with us. Let the elder brother with us, no problem, we agree to that.
Along with the documents.
Yes, it's both sides.
Oh,
As per the
last
order.
Yes. No issue. Let the exercise be carried out.
1 against 2.
One against-
Unfair.
No, I understand the title, man.
You are the referee.
Not an issue, but let the date be, I mean, let them have the exercise done. They're finding newer ways and means, to avoid it. It's-
They aren't, that is not the
I'm-
situation of,
That's correct.
those, yes.
Let it be done. It brings up both debates, no issues.
Heard 3S Bonic Learned Counsel for the petitioner. Also heard 3S, Dhar
And for 1 and 2.
for A Dhar Learned Counsel for the SPA numbers 1 and 2, and as well as 3SK Ghosh Learned Counsel for the SPA number 3. Full stop. The grievance of the petitioner is with regard to site inspection of the premises in question and also to decide the complaint lodged by the petitioner on the basis.
No, by us.
Huh?
No, both the parties.
I have raised the objection.
Is mistaken on
And also,
both parties. raised
also to
objection.
decide the complaint lodged by the rival parties.
Yeah.
My lord.
Full stop. For ready reference, the relief prayed for is expected here in below para. This matter had come up for consideration on 4/8/2025 and 6/8/2025, and a consensus was arrived with regard to the aspect that if such an inspection would be permitted, the grievance of the petitioner would be redressed. Both 3A Dhar Learned Counsel, Learned Counsel for the SPA numbers 1 and 2, and 3 Ghosh Learned Counsel for the SPA number 3 have submitted that they are not opposed to a joint inspection. Full stop. 3 Ghosh, the Learned Counsel has however hastened to add that such inspection has to be at the instance of the original landowner or his authorized representative. Full stop. Para. 3 Bonic, the Learned Counsel has responded, Learned Counsel for the petitioner has responded that the petitioner is the power of attorney holder of the original landowner who is his elder brother. And in any case, the original landowner would also be present at the time of such inspection.
It follows with the earlier order passed by the court at page 84, which directs what to do.
Till has came to a final decision, no construction would be carried.
That would be a separate prayer. That's a,
Because
that's a
that was
separate
the
prayer.
order.
Separate petition.
That is under check.
That will take care, that will take care.
Yeah.
In view of the aforesaid, situation, position, the writ petition is disposed of by permitting a site inspection of the premises by the parties in presence of the authorized representative of the respondent number 1. As observed above, the original landowner would be present in such inspection, which is to be done within a period of 15 days. 15 days from today.
Can it be on 20 days because the chairman is out of session?
20 days is.
4 would not be doing it, my lord. He would have the.
4 weeks, my lord.
Huh?
He's going for 1 month.
4 weeks.
Not,
Because-
within 3 weeks.
Yes.
Within 3 weeks from today. Full stop. It is also clarified that if the original landowner is, no, you have already made the submission, that's okay. It is provided that till such date of inspection, status quo as on today shall be maintained
Obliged.
By both the parties.
by the parties.
By the party.
Inspection along with the documents to be submitted.
It is needless to state that the rival parties would also provide the original documents pertaining to their claim
Much.
My
at
only,
the time of the inspection.
my only prayer, my lord, since they have dilly-dallied by years, so my lord, some word to put it within the bracket, that invariably it has to be done within the period of 3 weeks. That
Three-
one word would take care of it.
3 weeks, we have said 3 weeks, what invariably, 3 weeks.
Obliged.
Not
Invariably will add some uncertainty. Now it's within 3 weeks.
Obliged.
Disposed of, huh? If any mullah, yes, Mr. Abedin?
Instruction has received, my lord.
Hmm,
It says that it is not the final order, my lord. Report has been sought from the CEO. Thereafter, Deputy Commissioner will pass necessary order, my lord.
No, but would your lordship be pleased to go through the thing? It seems that now CO has come in. But over here, if your lordship,
My lord. they
over
have-
here, your lordship looks at annexure 2 and annexure 5.
He
no, the
put it in
annexure, the instruction is that that is not the final decision.
Yes, he himself says, my lord, it's not the final.
Then with that observation, it can
We
be
close
done.
it, we
Yes.
close it.
Yes, yes.
Liberty-
We leave this open. Why should we make them wise? If the same mistake is done again, you can.
Yes, I understand, I understand.
Heard Sri J. Abedin, Learned Counsel for the petitioner. Also heard Miss M. Burman, the Learned State Counsel, as well as Sri S. Dutta, Learned Standing Counsel, PNRD. Para. The petitioner is aggrieved by a communication dated 5/7/2025 issued by the District Development Commissioner Gwalpara, whereby the petitioner is sought to be disqualified under the provisions of the Assam Panchayat Act 1994. The petitioner has also put to challenge the communication dated 13/6/2025 issued by the said authority with regard to a hearing on the complaint laws against him. Full stop. Since the principal ground of challenge is the competence of the authorities issuing the impugned orders, this court had directed the Learned State Council to obtain instructions. Miss Burman, the Learned State Council has submitted that written instructions dated 12/8/2025 have been obtained, as per which it appears that the District Development Commissioner has only communicated the date of hearing and the final orders would be passed by the appropriate authority. Para. In view of the aforesaid submission is also endorsed by Sri Ratta, the Learned Standing Council, PNRD. Para. In view of the aforesaid clarification, this court is of the opinion that the petition has been instituted, the petition is prematured as no further action has arisen till now. Para. In view of the above, the writ petition is closed. It is needless to state that in case of any further or existing further grievance, the petitioner would have the liberty to approach the appropriate forum. Yes.
My lord, I think when your lordship has pointed out that there is statement that is not a final order, that means he is not qualified, disqualified. That has to be, my lord, mentioned because annexure 5 is disqualification order.
Decision is yet to be taken.
But
Deputy
that-
Commissioner, my lord.
Since as per the written instructions the final orders of disqualification is
Yet to be.
passed, comma. For all practical purposes, the petitioner would be treated to be an elected member, till such decision is taken.
Deeply obliged, man. It's disposed of, madam.
You want to be pending?
No,
You
no,
want,
sounds better, madam, disposed of.
disposed of, not dismissed.
Item 21.
Yes,
Thank
Mr.
you,
Sharma?
Lordship.
Nagaland, yes, madam?
Sorry.
Yes,
I'm appearing for respondent number 3.
yes.
Lord, it appears that he is supposed to be appearing before the police on 22/7/25. That
Hmm.
is quite, I don't know what happened after that. I will take notice on
But
behalf
he
of.
has made a point of law yesterday that there is a provision
My lord,
regarding the territorial jurisdiction, whether a statement can be recorded, a notice can be issued by a
And-
police officer to a person who is beyond his jurisdiction. It is at the investigation stage.
lordship.
My lord, regarding that, I was asked to appear on 22nd, my lord. I have filed an additional affidavit. Lord,
Hmm.
you may kindly come to page number
What have you
23.
stated?
My lord, I say, my lord, I was in bedridden condition since 6th of July. And I, on 20,
Okay, heard Sri T.R. Sharma, learned counsel for the petitioner who is aggrieved by a notice dated 28/6/2025 issued by the officer in charge, North Police Station, Kohima. Full stop. The primary ground of challenge is the jurisdiction and authority of the respondent number 3 to issue such notice under section 179 BNSS. Full stop, para. As regards the date fixed by the impugned notice, which was
my lord, that was on 22nd July 2025.
22/7/2025. The learned counsel has drawn the attention of this court to the additional affidavit
Para-
filed on 11/8/2025 and has contended that the petitioner was bedridden and therefore could not appear on the said date.
And I have communicated this with the, my lord.
Full stop.
Well,
The said fact has also been communicated to the respondent number 3. Para. Let notice be issued, returnable by 6 weeks. Whom is Madam Borman, M. Borman, State Council, 1, 2. 3 and 3 would be T. Crow, huh? Your AG,
My lord, addition.
the AG,
Additionally.
Nagaland, extra copies. 4 registered post with AD, para. 3 Sharma, the learned counsel, prays for an interim order, para.
And that there is a mistake, my lord.
Yes,
It should be repetition, my lord.
you have realized the mistake.
And
Better realize and don't make such mistake. Please. And has drawn the attention of this court to the provisions of section 179 BNSS. Full stop, para. After considering the same, comma, the operation of the impugned notice dated 28/6/2025 is suspended till the returnable date. Full stop. It is clarified that no coercive measures be taken against the petitioner till the next returnable date.
Lordship, I'm deeply obliged.
Take steps, Mr. Sharma,
Yes, my lord, I'm sorry.
take steps
Oh, yes,
For-
my lord, I'll do.
respondent 4. Mr. Bhuyan.
May I please, your lordship, my lord, we have filed an additional affidavit, my lord,
What has happened, my lord, on receipt of the MPU notice, my lord,
Hmm.
we have approached before the authority to submit our whatever document we have. But my lord, the state respondents, moreover, the authority who has issued the notice,
Hmm.
as my lord is not interested to accept those documents. And rather, my lord, they are now, even after filing or approaching before my lordships, my lord, they are now pressurizing that we should vacate. Verbally, my lord, even on the day on when this repetition was moved, my lord, at 2 p.m., my lord, the officials under the, my lord, district commissioner went to the petitioner's area, my lord, and said that you either vacate or we will have to demolish, my lord. That is the situation. We have put it on the statement.
Yes, Mr.
My lord.
Barbadari?
Forest is the appropriate authority out here.
Forest is a party.
My lord.
Yes, where is forest department?
And it will just after some time, let me give me a call to them.
Please ask them to be here
Yes.
after a while.
My lord.
Definitely.
Connected detail.
May I please, your lord?
Motion not I see.
Lordship, I am for the interlocutory application, Lordship, 3196.
Yeah, for?
The interlocutory application, I.
IA for?
3196.
IA for what?
I am for seeking leave of this honorable court to furnish the copies to the respondents, Lordship. Pursuant to the order of this honorable court,
You
Lordship.
furnish it, why do you want
That
leave?
is why, Lordship, we are ready to furnish the copies.
What is your grievance?
My lord, our grievance is that the Honorable High Court had directed that we should be heard and appropriate order should be made. But till date, notice has been issued, we appeared, but we have not been heard, we have not been supplied with the copy. At this juncture, the circle officer has informed us that he is going to demarcate the order without any specific order. My lord, he should give a speaking order, my lord, that's all, my lordship, after hearing us.
Yes, madam, you are for revenue department. Yes, what do you say?
This is to be done by the deputy commissioner.
No, circle officer.
And Bora is for respond number 5.
Respond number 5 with the, I do not have the copy, Lordship.
In a demarcation.
No, there are, how many repetitions are there?
Three, my lordship.
3 repetitions.
On 11/8/2025, your lordship has directed this present writ petition
To be-
455.
Yes,
to
it's to
come
be
along with
connected.
Lordship.
Laskar is for which, Raju Das?
Yes,
Yes.
my lordship.
4, 5, 5, 4, 25. And who else?
Item number, my lord, 24 and 25, my lord.
24 is disposed of.
Dr. Korobi Boro.
Disposed of.
Disposal.
Then 2097, Dalimi Garo, disposed of.
Respondent here.
Disposed of. What was the order?
My lord, order, my lord, is that the respondent should, my lord, furnish the copy of the boundary dispute case, my lord, to the petitioner within 2 days.
You were the petitioners in those cases. And who is the respondent?
Respondent, my lord, is.
Mr. Bora? He'll give the copies. And you are similarly situated. at-
Similarly situated.
Okay, we'll give the copies. Until that time, the circle officer will not pass any orders and give them an
But
opportunity.
regarding demarcation, lordship, we cannot do anything except remarking on.
Ah.
No position itself.
My lord, already we appeared before the circle officer. He
Okay,
also
okay,
heard.
okay. Heard. No. The repetition being connected with the IAs reported to take with Inter, the same are taken up for a common, for an analogous hearing and are being disposed of by this common order. Fair? The disposed of repetitions were instituted with the grievance that in a demarcation proceeding against the petitioners, the hearing was done in an improper manner without serving the copy of the application and other documents. The further grievance was that due hearing was to be granted. Now further claim was with regard to giving them a due hearing. Full stop. With similar grievance, the present writ petition has been filed. Full stop. Para. I have heard Sri S.B. Laskar, learned counsel for the petitioner, Sri petitioner in so and Sri N. Sarkar, learned counsel for the writ petitioners in the disposed of writ petition. Full stop. I have also heard Sri H. Sharma, learned additional senior advocate Assam, Miss Gorali, and N. Bodler, learned standing counsel, Revenue Department. Full stop. Sri M. K. Bora is present for the private respondent who has filed the IA. Full stop. Para. At the outset, Sri Bora, the learned counsel for the private respondent, who is also the applicant, has submitted that his client would furnish copy of the applications to the writ petitioners. Full stop. In view of the aforesaid statement, this court is of the view that there is no requirement to continue with this writ petition and IAs. Accordingly, the same are disposed of by directing the private respondent to serve copy of the application for demarcation on or before the date fixed. Full stop. It is also provided that the circle officer who would undertake the demarcation would give a due opportunity to all the writ petitioners, to all the stakeholders, including the writ petitioners, before passing any final orders. Let the date for appearance of the parties before the circle officer be fixed on which place?
Dispur.
Guwahati, Kamrup. You tell us the date of your convenience.
Any date, Lordship.
Today is 14th.
14th.
On 28th, is it okay? On or before 28th?
27, Lordship, it is not Sunday, Lordship.
Tell us, Mr. Bora, whichever date.
27, Lordship.
27 may not be the final date. He'll give the copies and thereafter the circle officer will fix a date for your. Yes.
My lord, for one small, two demarcation cases. One is 61/2019, another is
Demarcation cases, yes.
highly obliged, my lord.
Dispose of for you, huh? Both no, it writ petitions as well as the IAS stands disposed of. What ऐसा case type नहीं देखी होती demarcation cases. Much as India did already. Yes. Next.
May I please, your lordship, yeah, my lord, there is some mistake in my petition. Additional affidavit has come, my lord. Actually, there are two DAG, my lord. One is 26. Original DAG is 44 old, my lord. And it was, my lord, after that new DAG, two DAG. One is, my lord, one is 96 and another is 93, my lord. My lord, what happened?
New DAG, there were 90, 93 and 96.
93 and 96, my lord. New.
Okay.
My lord, what happened in the instant case, my lord? Petitioner number 1 is the, my lord, original royalty of Narendra Mohan Lahiri. And my lord, he is in the possession of the land from 1960, my lord.
1960?
61, my lord, it was mentioned. Actually, it is 1960, my lord. Then, my lord, petitioner number 2, my lord, he is in possession of the land, my lord, from 1982, my lord. Petitioner number 3, my lord, is from 1984, my lord. And petitioner number 5, my lord, from 1969, my lord. Petitioner number 6, my lord, is from the possession of the land from 1985. 5, my lord, from 1987, my lord. It is also stated from paragraph 9.
Okay, okay, now what is your
My-
grievance?
So before that way, my lord, petitioner are there, my lord. Now what happened, my lord? I have got the minutes of the meeting, my lord. In minutes of the meeting, that is said that this is not belong to TB hospital. I have annexed one document, my lord. Sarkari, my lord, dag, my lord. It was mentioned as a Sarkari dag. Now, Sita copy, it was mentioned as Sarkari dag. Now the petitioner tried to evict from the place of land, my lord. And another thing, important thing, my lord, there is a direction from this honorable court, my lord, that you first hear the order, petitioner and thereafter pass the speaking order, my lord. My lord, till today, no speaking order has been passed. If any passed, my lord, no copy has been served to the petitioner, meaning thereby no speaking order has been passed, my lord. That is my case, my lord. First day, my lord, look that whether it is a DAG number, my lord, this DAG number belongs to TB hospital or not, my lord. Then they pass a reason order, my lord. And
Yes,
if they pass
Mr.
reason, a
Bhattacharya.
copy served to me, my lord.
If Lordship may be pleased to, my lord, come to the earlier decision of this honorable court, my lord. Where, my lord, the similarly situated persons came up before this honorable
Page.
court. My lord, that starts at page 106. The judgment and order is a common judgment and order.
Yes.
And Lordship will find the relevant portion, my lord, at, my lord, page number,
143.
my lord, 155. 155. Those were the petitioners, my lord, in that batch of writ petitions, my lord, who were in occupation of DAG number 97.
Page
115.
115.
Madam, 155.
155.
155. I'm so sorry, madam. 155. 155.
Yes,
Paragraph number 50. May I read it, my lord?
yes.
Accordingly, this court therefore disposes of the instant batch of these writ petitions with the following observations and directions. Number one, the impugned notices under Rule 18 so issued to the petitioners to vacate shall be construed as notices issued by the circle officer Guwahati Revenue Circle to show cause why the petitioner should not be evicted by taking recourse to Rule 18 of the settlement rules. Number two, the petitioners in the present batch of writ petitions are given liberty
Okay,
to.
those we have read.
Yes. Then, my lord, number four.
Now, those we have read, we have to give a hearing, treat this as notices under 18 to give them an opportunity of hearing. Have you done that?
No, my lord, here what has happened, my lord, here the direction is of two parts. The notices are issued by the circle officer, but the hearing and speaking order has to be passed by the district commissioner. That is what has been laid down here. Now here, if lordship comes to the impugned notices, it starts from 169, Annexure 6 series. Starts from 169. This is one of such notice, my lord.
Yes.
Now, this has been issued by the circle officer.
Yes.
Whereas the undersigned had issued notices to the concerned individual by so and so directing them to appear for a hearing and to produce valid and land documents and or any other supporting material substantiating their bona fide claim of right over the government land under their
Yes.
occupation. Where so and so, the above mentioned documents have been duly verified, so and so, and not found acceptable. In view of the above notices hereby issued so and so to vacate. Now it appears, my lord, I have taken the instruction yesterday from the district commissioner. The circle officer had conducted the hearing. He ought not to have, considering the earlier direction issued by the honorable court. Now, under that circumstances, if lordship may be pleased, my lordship can dispose of this writ petition in the similar line.
See, Mr. Bhattacharya, there is a direction that the hearing should be done by a particular authority,
Absolutely.
but it has been done by another authority.
Another authority.
There may be an infraction, but the aspect of doing a hearing, that is done, but we cannot overlook the
Absolutely.
aspect that this court had wanted a particular authority to do the hearing.
Absolutely, absolutely.
You can redo the matter. We interfere with this action, not on the basis of the merits of the case,
Absolutely.
only on the basis that there has been
Jurisdiction will come.
an aberration so far as the direction, who will do the hearing.
Absolutely. Absolutely.
Whether it's
admittedly-
TB land or not, that will be for you to decide.
Yes. Finally, my lord, the speaking.
Mr. Chaudhary will have the rights to convince you that this is not
Yes, ma'am.
land, it is up to you. And if your decision is against them, they'll have the liberty to come before
Yes,
this
ma'am.
court, okay?
Yeah.
We never thought that Mr. Chaudhary's case would be over so soon. Normally,
My lord, normally, yes. All permutations and combinations, my lord, let apart.
okay, heard Sri N.N.B. Chaudhary, learned counsel for the petitioners. Also heard Sri Borua for State Council. S.R. Borua, learned State Council. No, the first, right, you right. R. Borpujari, learned Standing Council Revenue. And as well as Sri S.R. Borua, learned State Council. Para. The grievance of the petitioners, who are 7 in numbers, are against notices dated 30/7/2025 issued by the circle officer. Guwahati,
Got it, ma'am.
Guwahati, directing them to evict from the land under their possession. Full stop. Para. 3. Chaudhary, the learned counsel for the petitioners, has submitted that a similar issue was raised earlier in a batch of writ petitions, which were disposed of by the judgment dated 7/11/2024, in which certain directions were issued. Full stop. It is submitted that in violation of the aforesaid directions, the impugned notice has been issued. He has also emphasized that the land in question is not a part of the land reserved for the TB hospital, and the petitioners are in possession of the land since a long period of time. He has also submitted that the petitioner number 1 is a riotee since a long period of time, and these are relevant factors which are to be taken into consideration. Para? Per contra, comma. Oh, no, Sri Chaudhary has clarified that an additional affidavit has been filed today. Yeah, he got clarified now. Has informed that an additional affidavit has been filed today to bring on record certain clarification in the writ petition. Para. As regards the impugned notice, comma, it has been submitted that the circle officer Guwahati would not be the competent authority to issue the same in view of the clear direction of this court in the judgment and order dated 7/11/2024. Para. Sri Borpujari, the learned standing counsel, Revenue Department, while disputing the other submissions made on behalf of the petitioners regarding their claim for the land in question, and also that the same is not a part of the reserved land for the TB hospital, has fairly considered that the notice by the circle officer do not appear to be in strict compliance of the direction of this court. He, however, hastens to add that there is no prejudice caused to the petitioner, as the substantive relief granted to the petitioner to give them a fair hearing has been done. Para. To appreciate the rival submissions, comma, it would be necessary to look into the directions passed by this court in the order dated 7/11/2024, which reads as follows, page 155. Para. It appears that that this court, by the aforesaid order, had directed the Deputy Commissioner Kamrup M to give the opportunity of hearing to the petitioners. Full stop. The impugned notice, however, are not issued by the Deputy Commissioner, but by the circle officer. Para? This court is therefore of the opinion that without making any comments on the inter se merits of the rival parties, on the ground that the notice has been issued by an authority which was not mentioned in the direction of this court dated 7/11/2024, the said notices are interfered with and set aside. Full stop. The writ petition accordingly stands allowed. Full stop. Para. It is, however, made clear that the interference is only on the ground of the competence of the circle officer, and there will be no bar for the authority named in the order dated 7/11/2024 to take action in accordance with law.
Till then, my lord, I am already.
Then not be able
Yes,
to-
ma'am.
Lordship has already interfered, set aside. So there is no.
Set aside.
Yes, yes.
I will immediately convey, my lord.
One case is without notice, they are evicted. I find that. It will
My
come
lord,
with us.
with all respect, my lord, the Lordship has observed the authority. My lord, if it can be clarified, my lord, the District Commissioner Kamrup Metro.
Why should it is there? We are quoting the
My-
para 50 will be quoting.
I'm obliged.
HR Chaudhary.
Yes, my lord.
Yes, what
In
is
this
it?
case, my lord, the respondent number 7 contested election on the strength of an false education qualification certificate.
Who are you?
I am the voter of this locality.
Voter of which ward?
Ward number 1, my lord.
And the respondent number 7?
Respondent number 7 now is the member of this.
Now
ward
he has
number.
been elected from ward number 1.
She was elected from ward number 1.
Okay.
So
But you are a voter, okay. Same, we'll issue notice maintainability.
Maintainability open, man.
Open. Hertz.
one, my lord, interim I am stating, my lord, pendency of the writ petition shall not be about to dispose of this representation filed before the district commission.
Hertz free HR Chaudhary, learned counsel for the petitioner. Para. As per the facts projected, the petitioner is a voter of ward number 1 of 82 number Bandar Puna Gaon Panchayat in the district of Sribhumi.
Sribhumi.
Full stop. The grievance of the petitioner is with regard to the candidature of the respondent number 7 and her subsequent election as a ward member. It is contended that the said respondent number 7 had submitted forged documents, and in this regard, the petitioner had submitted a representation to the district commissioner on 26/5/2025. Full stop. Para.
Which is documented on 27/5/2020.
Okay, let notice be issued, returnable. No, three endas, both three endas, London State Council and Sri S. Datta, London Standing Council PNRD, has, however, raised the objection of maintainability on the, questioning the locus of the petitioner, as he is not an aspiring, he was not a candidate, but only a voter. Para. Be that as it may, let notice be issued. Returnable by 4 weeks, 6 weeks. PNRD S. Dr. 1,
1, 3 and 6.
1, 3 and 6. Election. RDB was around, I think.
No, my lord.
Is he there today in the court?
I don't think so. Well.
AB Kayastha,
Her name may be recorded.
is he there? Is she there?
I don't.
We want to have to record somebody who's in the court. Please get whoever is in the court. No, blank code. I think Dubey was there in the morning. I don't know. See, RDB public AB Kayastha.
He's out of session, I think. My lord.
Or then AB Kayastha Sabasam. Try to inform AB Kayastha.
Yes, yes. I'll inform them.
If not, then we'll have to change the wordings. Three Nelekiba hole. Let notice be served upon three, upon notice upon response number 3 be served through the standing council 3 R Dubey. Notice upon response number 6 by registered post with AD. Para? Pendency shall not be a bar for consideration of the representation said to have been submitted by the petitioner. Extra copy report. Yes.
Another form, I kindly may mention that, representation is another form.
Okay. Representation.
That is I read.
Next.
Hello.
28 is again HR Chaudhary, yes.
This is my composite land transfer matter. My
Hmm.
In this case, my lord, I have applied on 18/5/2025. Till date, it is under process.
18/5, okay.
Yes, ma'am.
Heard Sri HR Chaudhary, learned counsel for the petitioner, who is aggrieved by the delay in disposal of the application for transfer of land. Full stop. It is submitted that such application was submitted on 18/5/2025. Duta submitted with this contented developer, no?
Due delivery date, my lord,
Para,
7 to
that
20.
notice be issued, returnable by 4 weeks. You take instructions, Mr.
My lord.
Revenue, Madam PR Mohanto, 1,
I'm 2345.
2, 3, 4, 5, and extra copies. Right.
Extra copy to it was here.
My senior is on leaks in code number 6, my lord. Can it be taken up after some time?
What is the matter?
But I'm not on record, my lord. I'm not well acquainted with the facts.
The building constructed by the petitioner is beholds the norms according to JDA. After hearing that given opportunity,
Okay, we'll have sometime later on Wednesday next. Okay.
well, can it be on a hearing there for that?
Thursday next.
Thursday?
No, but these are old matters, 19
No,
matters.
that is why there is stay.
No, we are not adjourning. We are not adjourning. Let him come.
No, can it be on 29?
No, let him come. 19 matters, we are not adjourning. Let him come.
Obliged.
Lord, here I have received instruction, but that instruction is not sufficient from my understanding. Lordship, I need some clarification on that instruction. Today only I have received it. 1 week, I mean, maybe. Well, Lordship.
Okay, Thursday next.
Yes.
Okay. Heard Sri O.P. Bhatti, learned counsel for the petitioner. Para. Sri B. Chaudhary, learned standing counsel. Finance Taxation Department has however submitted that though instructions have been received, some time may be granted to seek certain clarifications. Para. In view of the above, matter is adjourned to be listed on Thursday. Date.
Lordship, in this case, we have been directed to obtain certain instructions and to file an affidavit. Lordship, may I pray for some more time?
What is the matter, Mr. Roy?
The demolition of my mall, my market.
Mall,
Yes.
According to us, it
already
was an-
demolished.
Some part of has been demolished and I was instructed that is the other part I have to demolish, my lord. And apparently, my lord, this is a case, my lord.
Is there any interim order?
Yes, then there was an interim order. In spite of that, they had demolished. And no, without any notice, my lord, within 24 hours. And in the affidavit, my lord, they have
stated that the some government that I have enclosed, my lord, but I have annexed the trace map also, my lord. There is no government that, my. Government.
Let him have the heard Sri S.K. Roy, learned counsel for the petitioner. Para. Sri H. Sharma, learned additional senior court advocate Assam, has however paid for some more time to obtain the instructions and file the affidavit in opposition. First of it is noted that the respondent numbers 8 and 9. Who are 8 and 9?
Deputy Commissioner, Deputy Commissioner was it?
Huh? 8 and 9.
9 and circle officer.
Then you want instructions from whom?
Well,
8 and
instruction,
9.
not affidavit has to be filed by the Deputy Commissioner.
We-
right?
Initially,
Clarify-
Lordship, we have filed an affidavit in opposition.
By the Hojai.
They have filed a reply, Lordship. In some anomalies were found. Accordingly, we have directed to file an affidavit clarifying all those.
Okay,
facts.
so I don't like this. People, Sri H. Sharma, learned so has submitted that though the affidavits have been exchanged, some clarifications will be required,
Lordship.
for which he prays for little accommodation. Para, in view of the above, matter is adjourned to be listed when?
Last part of September, Lord, 23 meter, interim,
Well,
we have not yet received any instructions.
On 5th of September,
Interim. Medical.
5th of September.
May I pray for us?
Then 10th of September.
Lots.
10th of September, para interim order passed earlier to continue till the next date of business.
Okay, sir.
Yes, next.
Thank you, Your Lordship. Lordship, as per order 25/7/25, my lord, respondent now for praise 2 weeks time to file affidavit in opposition, my lord. It has not been filed yet.
You are for 4, or
Fine,
4.
no, my lord. On instruction, I am appearing for the municipal board, my lord, 2 and 3.
Who is for 4?
Private res-
Today I am appearing entrance for respondent number 4, my lord. 2 weeks time may be granted for filing my affidavit in.
But last time you had appeared, that was in July
Might
2025.
now be different sets of lawyer, my lord. Actually, they
And
have made me perform a
Mr.
different-
Chakraborty would also be appearing, filing.
2 weeks, my lord.
Okay. Let them file the affidavit, okay? Oh. What is your name?
B. Saikia, my lord.
Heard Sri B. Soikia, learned counsel for the petitioner. Also heard Sri basically also heard lecture. Sri B. Chakraborty, learned counsel for the respondent numbers 2 and 3.
On instruction, my lord. Power is in transit, my lord.
Learned counsel, which our learned counsel has submitted that he has instructions to appear on behalf of respondent numbers 2 and 3. And the power would be filed shortly. Full stop. 3. B.K. Singh, learned counsel, has appeared for the respondent number 4, has submitted that he has entered appearance for the respondent number 4.
Today.
Para. Both Sri Chakraborty and Sri Singh, learned counsel, pray for and are granted 3 weeks time to file affidavit in opposition. 3, and as learned state council is present, list after 3 weeks.
Well, a date may be fixed, my lord. A date may be fixed.
Yes, list on Mr. Chakraborty.
Lord.
1, 2, 3. List on 8th of September.
Much obliged.
My lord, 9, can it be on 9th?
9th is again a Tuesday, then 10th.
10th, ma'am.
10th.
Highly
Much
authorized.
obliged.
Item 9.
If I'm appearing for respondent number 3 to 5, perhaps we require further time to file affidavit.
Who are 3 to 5? CGST.
Central state is also party.
State would file affidavit.
On last occasion, Lordship, my learned friend said that he.
State who's for the state GST?
Much of the previous order, if it is produced, the finance department had sought time to.
Yes, we have seen that. That was on 18/7/2025.
Lots.
You should file it. Wait, who's for the state finance?
The Gogoi was there.
Mr. Chaudhary?
In this case, probably Gogoi is.
No, who, Mr. B. Chaudhary was there in the
Yes,
court, that is why.
he was there.
Who has not been seen. Yes, madam? No, he has to make a prayer. We do not know what is the status.
He told me that he also required some time because they have also not received any instruction.
Okay. Both both Sri S.C. Kyle, Standing Council CGST, and Sri B. Chaudhary, Learned Standing Council Finance Taxation Department of the state, have renewed their prayer for grant of further time to file the affidavit in opposition. Para. In view of the above, further time of 3 weeks is granted to enable filing of affidavit in opposition. Para. Interim order passed earlier to continue till the next day of listening.
Much date may be fixed, your lordship, if it is possible.
List on. Oh. Is it 8 is okay for you? 8 September. Mr.
Acceptable will be short, lordship.
Why? 3 weeks you have said. Then
16.
16 will be 4 weeks. More than 4 weeks. On 10 September.
Lots. Much obliged, your lordship.
Item 10, Mr. Ali, where are you?
Lordship, we have already responded, your lordship.
Review for what?
Review of this Ericsson D, your lord.
Who is pressing the review?
Annexure,
Government, Secretary Government of India. Yes,
Annexure
CGC.
H.
Which CGC?
So there is nothing, your lordship, in the review. The review has been filed, your lordship, against that order. It is a land acquisition matter, your lordship. Acquisition was made, your lordship, in the year 2013. Till today, they have not paid a single farthing, your lordship. It is land measuring 21 bigha, your lordship. And
Now, what
15
what are the grounds of review?
Now the direction is given by the imperial order, your lordship, that amount should be paid within certain time, 6 months, your lordship. That 6 months elapsed, your lord, 2 years ago. They are not paying. After that, your lordship, they have come with this petition, your lordship, for review of the.
Now, review on what grounds?
No ground, your lordship.
Yes, Mr.
They have
Abra.
challenged the judgment, your lordship. Illegality, your lordship. The judgment in the under the guard of review.
Yeah, what are your grounds of review?
Whether the cost title has been corrected or not, because they are substituted after that, they have to file a corrected cost title.
It is your review.
No, they've moved the petition.
Review by whom?
Review by me, lordship.
Then, what petition?
They filed a substitution petition that was allowed,
Substitution.
lordship.
Then,
So our main lordship respondents died, your lordship.
you press your review. Those are secondary matters, whether substitution.
Anyway, lordship, I am ready to submit.
What are the grounds of review?
Lordship, what happened in this case, lordship? The writ petitioner did not challenge the award. After an award was after that, the appropriate authority passed an award. After 3 months.
Mr. Ali, please have your seat. We'll come to you. Yes. Award not challenged.
Not challenged. 9/8/19, the reference case was allowed, lordship. 9/8/19.
9/8? The writ petition was allowed.
No, reference case.
Referenced by the district judge.
9/8/19.
This is under the 13 Act or?
13 Act.
13 Act.
13 Act.
Okay, then?
Then the writ petitioner claimed that on 2011-19, she filed a petition seeking the similar relief. That she could have done, or she under section 73, provided that was filed within 3 months. Now, this petition does not bear any acknowledgement from our part. The acknowledgement, lordship will find acknowledgement only in lordship. Petition filed on 11/2/2020.
even lordship consider 2011-19, that is also not within 3 months. So the same benefit she cannot claim lordship in
these
view of
are
section 73.
Mr. Chakraborty, we are on a review jurisdiction.
Lordship,
The-
this matter was not pointed out before this court, lordship.
these-
The matter was,
These are not
decided.
factual points which you could discover after the judgment. These are points of law.
lordship.
You have not pointed out, this can be a ground in an appeal. How can it be a ground in a review?
Lordship has just 71 decision, lordship, where it has stated, lordship.
Review jurisdiction, you know our limitations. Unless you show that error apparent on the face of the records, error apparent.
Lordship, just one line for
You
division.
cannot file a review in the, or rather file an appeal in the guise of a review.
Lordship, only one line, lordship.
Which one? Which one?
It's a division bench judgment,
Of
2010 2 GLT 548,
2010?
relying on a Supreme Court judgment, lordship. 2010 2 GLT 548.
548. Why don't you cite the Supreme Court?
Lordship is quoted from the Supreme Court.
You
this
should,
para.
you can cite the Honorable Supreme Court judgment.
Lordship.
What is the judgment of the Honorable Supreme Court? Which one?
Lordship, it's
Aribam.
1997 10 SCC 592, Surjit Singh case, lordship.
Which
Paragraph
paragraph?
17, lordship. The appeals court in so and so, in which tribunal refused to correct the mistake on technical ground, held that when a patent error is brought out to the notice of the
That
tribunal.
is the law. You make out a
Tribunal is
patent error apparent on the face of the records.
Lordship. Had this might have been brought to the court, lordship, the things would have been different, lordship.
If you are not diligent, and it is not a fact that you could discover this after the judgment, may not be a case for it. Yes, would like to say anything? We are dismissing it.
My submission would be, your lordship,
Dismissing.
they have selling the facts. And no new, actually, grounds your law on law.
Because they didn't
Uh,
file
this-
any elaborate affidavit, only that we made the money
Not
before the deputy
your lordship,
commissioner.
this is the review.
That is the only,
Who? They are not
Deputy.
supposed to.
now our affidavit was
Yes.
not
Okay.
in details, lordship.
Yes, yes, yes. Okay,
Review is only for
okay,
correction.
we'll pass detail order. We're dismissing it.
Lordship.
Your lordship, may I say, your lordship, that the respondent may be directed to pay, make the payment, your lordship.
That will be, the lordship.
We'll
will
dismiss
not
the
pass
review.
in
We
the-
cannot say.
Because since 2013, your lordship, this is
You know what to do to
If- if-
execute.
15 years, your lordship, they have not paid anything, 21 big of land, your lordship.
Okay.
So if one line added, your lordship, that the respondents are directed to pay the amount within.
There has to be an application from you. We are only deciding the review. Okay,
Lordship, for justice sake, your lordship, that can be added, your lordship. Make
Oblige,
the
your
payment within 3 months, your lordship.
Okay, next. Yes.
My lord, this matter, my lord, we have challenged the order of the banking ombudsman, my lord, RBI banking ombudsman. My lord, initially, we have
Reviewed it. You are challenging the ombudsman order.
ombudsman order, my lord. But there was a complaint made against the bank, my lord. The petitioners herein are senior citizens, my lord. And
How many of you are there?
two, my lord, husband and wife.
You filed a complaint in the ombudsman.
Initially, we filed complaint before the SBI, my lord, regarding fraudulent transactions which took place in my account, my lord. And when that complaint was not addressed to, my lord, we have approached the banking ombudsman.
Hmm.
My lord, initially, my lord, and simultaneously, my lord, we have also lodged an FIR. So, my lord, I will take, my lord, to annex page 34.
3-4.
34.
Yes.
34A, my lord, 34A, it is a typed copy of the FIR registered before the officer in charge, Hatigao Police Station.
Yes.
Wherein, my lord, I have informed the IO that, my lord, that from my account, on account of, my lord, if I may read the FIR, my lord.
Please.
This is for your information that I and my wife hold account with SBI PBB Ganesh Guri had received a SMS yesterday regarding the blockage of my BSNL SIM card, and a number was given over SMS, which I contacted to my SIM. I was misled over the call to give my bank details along with OTP even before I could realize there were multiple transactions from my account along with my wife's account, the details of which have been mentioned below. At around 7 p.m., we lodged a complaint at the toll-free number of the SBI against fraudulent activities and blocked over cards and other transaction gateways. The actual amount of fraud is yet to be known, which I can collect from the branch tomorrow. Please do the necessary action, help to recover my bank balance, which have been saved from my pensions. So, my lord, two accounts were involved. One of my wife and one husband and wife, my lord. From these two accounts, fraudulent transactions took place. On the same day, my lord, on the subsequent day, I have filed a complaint before the branch manager of the PBB Ganesh Guri SBI branch. Case 35, my lord. This is for your information that I hold a savings bank account with number, my lord, so and so with your branch. On day 1/6/21, I fell prey to a telecalling fraud wherein my above mentioned
Yes,
account.
now, okay, we are not on the merits. Then what has happened?
Thereafter, my lord, these
Some
letters.
fraud was done upon you, your money was siphoned from your account by, okay, then what had happened?
My lord, then when no responses were given by the SBI, my lord, thereafter we have given several other representations also. Then,
Now,
my
what is
lord,
the
we have-
grievance of the, what is the reply of the banking ombudsman by which you
No.
are,
Yes, ma'am. That is the interim order,
page?
page 61, my lord, annexure 14. My lord, the petitioners herein are citizens, senior citizens, my lord, and they have never activated internet banking in their life. These accounts are, my lord, 15 to 20 years old. They have never activated internet banking or, banking. Now, my lord, when the complaint was made to the ombudsman, my lord, this was the reply given by the ombudsman. At page 62 is the operative portion. We thank you for complaint number so and so. The complaint pertains to unauthorized INB transaction consisting of UPI as well as YONO cash withdrawals done from 3 account numbers. My lord, 1082, my lord, so and so 100 and 100 ending with 841. My lord, from 1/6/2021 to 9/6/2021. Chandrakanto Kolita, Bharti Kolita, and my lord, the third one is a joint account of both husband and wife. The bank version was submitted to us on 18/6/21, stating the transactions were done via UPI.
Who are appearing? You are for the State Bank
I am
and you are for the RBI. Banking ombudsman is, who's appearing for banking ombudsman?
And
Yes, what is your take?
well, before going to the order of the banking ombudsman, let's reach out the application to the complete to the banking ombudsman and the relevant circular regarding the.
Now, how do you address this kind of problems?
Madam,
Mr. Gupta is before us representing his clients who are senior citizens, but
My lord.
these are very common issues, common problems. How do you address this?
My lord, that the fact.
What steps do you take to recover the amount? Unless in a given case, you find that these complaints are not bona fide.
That is.
95%
My lord.
are bona fide complaints.
We have
I'm not saying 100%,
Yes.
5% maybe.
My lord.
But from here, it does not appear that they were hand in gloves or something like that. Money has been siphoned off from their account.
My lord, prior to that, my lord,
Yes.
may I point out the situation, how the money was transferred, my lord? That complaint to the ombudsman at page.
Now we understand they had given their OTP, which they
Everything, my lord.
should not have given. It
Everything.
happens. Now, not to talk about senior citizens, even a very smart
My lord,
person
it
can give an
happens, my lord.
OTP.
We have
It will
filed-
be conveyed in such a manner
Yes, my lord.
that something is going to happen, so you give the OTP.
Well.
They have various ways and means to do.
Here, what has happened, my lord, not only the OTP was compromised, but there was a change in the registered mobile number. And the settled rule is that, my lord, the registered mobile number cannot take place without submitting the KYC documents physically going to the bank. Here, my lord, two vital things have happened, my lord, which perhaps
How much is the amount involved?
around 10 lakhs, my lord, 10 lakhs and above, my lord. 10
What
lakhs.
is the stage of this police case?
But they have submitted the charge sheet, my lord. They have submitted
That
the
is in
charge sheet.
Guwahati.
Yes.
Do you have a copy of the charge sheet?
My lord, in the affidavit file, they have, my lord, stated, my lord. The affidavit filed by the respondent number 6, my lord. FR number 66 dated 31/1/2022, my lord, in Hathigao PS case number 400 of 21, and FR number 788 dated 30/12/21 in Hathigao PS case number 428 of 21. So final reports.
Final reports?
Final reports.
Or not final form, final report in the form of, final form in the
Whether
form
it-
of final report.
Whether it is an FR or
FR, you
charge
said.
sheet, my lord.
Charge sheet is not written as final report. The
Final
explicit is
reports-
final form. It can either be a final report, it can either be a charge sheet.
Yes,
Now
sir.
here is a final report.
Yes.
So there is no, nothing found in the investigation.
Yeah.
That is also very strange, my lord. But, my lord, the RBI guideline says, my lord, in case of a fraudulent transaction, if the customer informs the bank within 3 working days, my lord, then the liability of the customer is 0.
That I am going to
Here-
point out, my lord. That
Here,
page
it
65.
happened, my lord, the fact that the petitioner has informed the bank within the 3 days period, my lord, that has been, my lord, disputed by the state bank, my lord, wrongly, my lord. It is their own statement, my lord. We have informed the SBI on 2nd of June regarding the fraudulent
Next
transaction.
date,
Yes, within 3 days.
next date itself.
Next day
1/6
itself.
you say that the incident has happened.
On first,
of
my lord.
June.
On first, in fact, we have already by tele, my lord, online complaint, we have registered. Tele, my lord, complaint was also given on 1st of June itself. That fact have been disputed by the SBI wrongly, my lord. And
What is your documentary proof
There is
to?
no proof, my lord.
yes, there is a proof, my lord, I will say. And in fact, in the affidavit, my lord, they have not denied the fact, my lord. The affidavit is completely vague and silent on the
Where is the
governments.
Mr. Gupta, is the rejection order on the account of delay in lodging the complaint or anything else?
No. Yes, it is on, because, my lord, from
No, is it on the merits of the complaint or on the delay in lodging the complaint?
on the, my lord, delay, my lord. Because the RBI ombudsman, my lord, have refunded my money for the unauthorized transaction from 4/6/2021 onwards. That is the date when the RBI has taken it to be a date for the complaint. And, my lord, if I may take, my lord, to page 62. My lord, 6th line from the bottom, my lord, page 62. Hence, the deficiency, my lord, if I may read one line above that, it was observed that even after the complainant has lodged the complaint on 4/6/21,
there were multiple debits and credits taking place in the account of Bharati Kolita. Hence, the deficiency lies with the bank as they failed to mark hold in the account immediately, and rupees 1,34,600 was debited from 4/6/21 till 9/6/21. In view of the above, an advisory was issued to the SBI to pay the disputed amount which was debited even after the complaint was lodged, and they have complied with the advisory on 18/11/21 and credited 134,600 back to the complainant's account on 18/11/21 in good faith.
So where does they get this 4/6/2021? Date?
They have taken the date of complaint, my lord, made to the SBI as 4/6/21
No, when did you approach this SBI?
on 2/6/21.
Where is it?
My lord. Page 35,
3/5.
3/5, which I read earlier, my lord. The vernacular in original is at page 37 and 38.
Not that.
That,
In fact, my lord, immediately after, my lord, filing an FIR on first, the petitioners went to the bank and, my lord, filed these written complaints, but formally no receipt was taken. However,
where is your FIR?
FIR, my lord, 16. My lord,
Where?
Page 34, my lord, 34. Type copies 34A.
FIR?
Yes. 33, I'm sorry, my lord, annex 333. 16/20.
No.
At 9:10 PM, my lord, that is the date on which the fraudulent transactions took place.
This at 34C.
34C is the written is a my lord, which was registered under 154 at page 33.
This is 16.
16. And along with the, my lord, the FIR, my lord, will take page 29, which is the statement of account given by the branch. Page 29. That was the statement, my lord, when the petitioner's son approached the branch, my lord. The branch manager gave the statement from the account and requested to file in formal FIR before the police. And that is evident, my lord, if my lord will take page 29. The statement date is there.
Both Mr. Das and Mr. Hazarika, if the rejection is only on the basis of the delay, then that would
No,
not
my
be
lord,
proper.
that specs is quite different. What happened, my lord? We have the bank, my lord.
Let us see the ombudsman order again.
Yeah, my lord, but
Page
before that,
60.
my lord, I want to conclude one line, my lord. That there is a RBI directions, my lord. 7.1 is said when bank is responsible, 7.1 is said when the customer is responsible, and 7.2 is the when the bank is responsible. Now, question is, my lord, 134, my lord, 1,34,600 was refunded back to the petitioner, my lord, as per the advisory note of the ombudsman, my lord. There is a clause, my lord. There is a fraudulent transaction period was 1st June to 9 June, my lord. That is the period. According to our stand is that he informed my lord on 4th June, my lord. Then, my lord, after 4th June to 9, my lord, there was another fraudulent transaction was happened. Then, my lord, ombudsman directed that bank has not even received the information regarding fraudulent transaction on 4th. They have not hold that account. We have made an hold on 9, my lord. So 4th up to 9, my lord, that period was, that amount fraudulent transaction was 1,34,600, my lord. That was directed to us to refund the petitioner, my lord. We have refunded that, my lord, as per advisory note of the ombudsman. Now, question remains, my lord. Now, it is admitted provision that he share his credential, everything, ATM details, OTP, everything, my lord. As per RBI guidance, he is responsible, my lord. Then RBI guidance he annex here. Now, question is, my lord, he said, he now claiming that he informed to the bank on 2nd, my lord. Our stand is, my lord, or we have received on 4, my lord. I have, in my additional affidavit, I have categorically said, there is a no, if through this additional, we, my lord, request to the petitioner to prove that he has filed that complaint before the bank. Only obtaining a statement is not enough, my lord. He formally informed to the bank on 4, my lord, as per our trial mail and the receipt copy of those, my lord. So, for the period, between the period 3rd June to 4th, my lord, that transaction, that amount, my lord, we are not responsible. That is the fault, my lord. Only State Bank has advisory, my lord, ombudsman.
Aren't your accounts insured?
No, my lord.
You take instructions, your accounts are all insured.
No, my lord, we are followed the RBI guidelines.
Your accounts are all
Now,
insured.
here is a case, my lord.
Mr. Das, kindly take instructions. Your accounts are all insured. You do an internal inquiry if there is foul play on the part of the account holder. If there is no foul play, the accounts are all insured.
My lord, recently another case was settled, my lord. Where, my lord, here is case also similar nature, my lord. What even, my lord? That SMS was sent to the duplicate same holder, my lord. He has not made a party to the, my lord, service provider. Now, my lord, when the issue that there is a, my lord.
Mr. Das, there are certain cases where we have to take a different view. 2 senior citizens have come before this court. This is not an event of 2025. Even today, if a phone call comes to you, a smart lawyer, there is every possibility that you will also be duped. It's not something extraordinary. These are old persons. SMS came that your VSNL is going to be deactivated. Share your details. At the spur of the moment, it was done. Even today, it has been done. These are reported almost on daily basis.
My lord,
We are not saying that.
Most of the cases.
We are not saying that somebody who is not diligent should be, but you have to deal with a practical view. Seniors is 75-year-old. These are means and modes adopted by the fraudulent, fraudsters. They will say something which is like disconnection of electricity. Even any one of you might have got a the bank account will be disconnected, will be frozen, electricity will be disconnected, phones will be disconnected.
Yes.
So this is not something, and while dealing with persons of, at the time of filing a 75-year-old hard-earned money, instead of taking a technical view, you may be correct that if you go by the date from 4th to 9th, we have given back, because instead of the hold, put on hold, we did not do so, whatever activity. But how do you really address this kind of an issue? This is not a very unique thing. It has been happening.
In WPC 372021, it was listed yesterday. We have filed a comprehensive affidavit to what measures have been taken by RPM.
No, see, we are not doubting the steps taken by the RBI, which is the highest authority to oversee the banking regulations, and even the SBI. You also have to work within your the confinements of law, but something has to be done.
But the registered mobile number.
What about, there are many cases of this nature? How are
Yes,
those
my
being
lord.
dealt with?
One recently, my lord, settled, my lord,
Yes.
where, my lord, that Airtel was in the similar sequence, my lord.
Yes.
They issued that the Podstar had, my lord, obtained the duplicate SIM, my lord. Then, my lord, Airtel has paid 12 lakhs, my lord. Very recent judgment, my lord, I have, my lord.
Is it your case that there is a fraud?
Yes, my lord,
system?
message was delivered, but duplicate SIM was
But
issued.
there is a negligence on the part of the SBI. They ought not to have allowed the change of the registered of mobile number, my lord, without the KYC document. That is the flaw, my lord. What I am submitting
No,
before.
no, Mr. Gupta.
My lord.
There are certain case laws, I think from Delhi High Court,
My lord.
in a matter of this nature, involving senior citizens. Have you got any case laws?
My lord, I have 2 judgments of our High Court, my lord, wherein, my lord, it has been allowed, my lord, taking into account that the complainant has approached within 3 days. No, that is two other passes. No, the matter pertaining to Honorable Justice, my lord.
We know
P.
this, we
Agarwal
know this.
also.
One judge of this, honorable judge of
Yes,
this
my lord.
court retired and one advocate, learned counsel were involved.
Yes.
They were the parties.
Yes, my lord.
And the earlier case has been referred in the case of counsel, Mr. Bhomik. What is the other case?
May I pray, my lord, it may be taken 3726 of 2021, my lord.
My lord, paragraph 20 of the judgment, paragraph 20, my lord. Nineteen and 20, if I may read, my lord. From the reading of the relevant provisions of the RBI circular, what can be seen is that clause 8 deals with third-party breaches where the deficiency lies neither with the bank nor with the customer, but lies at
What is this DAV school? 1920 SCC 31? The Supreme Court judgment? 2019 20 SCC 31? We'll have this
No.
next week. You also take instructions on the aspect of the insurance of the accounts.
Insurance of the.
Insurance, all accounts are insured.
My lord, then my lord finally.
There are third-party insurance and there is an internal inquiry done regarding the possibility of involvement of the claimant.
Yes, yes, my lord.
If the due diligence exercise is done, the amounts are insured.
My lord.
Okay.
In fact, my lord, on 1st of June itself, my lord, I have registered by online that my lord, SMS DLR sheet which I have produced.
Yes.
My lord, I have informed the SBI on 1/6 at 7:53 PM that and your complaint has, but that message has been sent to my lord that false duplicate.
Then that is why I am saying, my lord, without
registered mobile
making him a
number.
party of the, my lord, service
My lord,
provider.
dear customer,
BSNL,
your
my lord.
complaint has been registered.
We have, my
This is
lord,
the complaint number.
message
So
sent to,
SBI
my lord,
was-
I don't know, my lord.
SBI was informed internally. What they have done, my lord, thereafter?
Message was
Why
sent.
they have not frozen my account immediately on 1st of June itself? When the complaint was lodged? And how can the registered mobile number be changed, my lord, without the KYC documents? Here, two things have happened, my lord. My internet banking, the customer has never activated internet banking in 25 years. His internet banking was activated first and then the mobile number was changed. Two events have happened. First event, my lord, all right, my lord, I have compromised the OTP. Internet banking has been activated.
Okay.
But the second.
Heard Sri H. Gupta, learned counsel for the petitioners. Also heard Sri K. Das, learned counsel for the State Bank of India, and Sri P. Hazarika, learned counsel for the RBI.
By 120.
Para? State is there. Miss M. Bormond, learned state counsel is also present. Para? Both Sri K. Das as well as Sri P. Hazarika, learned counsel are directed to obtain instructions on the aspect as to whether the account in question was insured. First of list. After list on when? Today is
20.
14. List on 28,
28, my lord, I have.
27?
20.
27. Your statement regarding giving of the information on 1st of June in the petition, what is the response?
In the affidavit, my lord, they have not responded to that. They have not responded to that. That is, they have kept it vague.
Then from 1/6 to 3/6/4/6, I think you will have to be replenished.
Orally, the submission is made that he has not made, but in the affidavit, there is no denial of the fact that on second.
We will look into this aspect.
My
If
lord.
there is no denial. Okay. Next.
Sorry, my lord, I had to go to revenue board.
Doesn't matter. Yes. What is 22?
Lord, the matter relates to, my lord, a proposed eviction, we are apprehending, my lord, and basing on a notice. My lord, may we please to find the full notice is at page 136.
Yes. Yes, instructions.
My lord, they had, my lord will kindly peruse order of 11-8.
Yes, they said that they had.
They have filed an affidavit, but my lord, not in that context. The order was passed in different context. Lordship will kindly come to paragraph on perusal that premises of passing that order was different, my lord, and affidavit is totally different. Additional affidavit which they have filed. It doesn't,
On the president, it is however revealed that such course of action was taken as no statement supporting. It is not revealed. Statement has been made. As one represents premature and as the order put to challenge is a so-called and nothing on it. Yes, your affidavit has, no, he says that in the what we have, we recollect that replies were attempted to be submitted, which were not accepted.
Right.
That is what he has said.
yes. So in that context, he could have brought those purported replies within this affidavit on record.
Lord, those
That
were-
was the context of passing that order.
Lord, those were not written, my lord. When we, my lord,
Ah.
if we go
No,
by
no,
the, my lord, if we go
No,
by.
no,
the
you have to
notice-
give a show cause notice has to be replied, not only by written, you have to give the documents also.
No,
You
no,
cannot
that-
reply to a show cause
My
orally.
lord, that attempt we have made. That attempt we
No,
have
where
made.
are the replies?
My lord, it is a mass, my lord,
At
exercise
least some
that we have done.
samples.
My lord,
How many of you are there?
my lord, we are now here, my lord, 180% are.
One or two, at least
My lord.
2, 3, that these are the, and you
180%.
crave leave.
No, not a single whisper, my lord.
No, my lord, we have stated in the affidavit, my lord, additional affidavit that attempts were made.
Attempts were made, but you are saying that orally you had gone
My
there.
lord, orally, my lord, when we.
Different stance.
Where is the additional
With, my lord,
affidavit?
with the documents we approached, my lord, before the authority.
No,
but
not
they-
documents.
My lord, they have declined to accept the same, my lord. That
Let us
is the
see,
problem.
let us see your affidavit.
My lord, my lord. My lord, may I please to find, in paragraph 4, my lord.
No. A reply, show cause reply.
My lord,
This is
that
a
was-
vague paragraph, my lord. They have stated that they have approached the concerned revenue authority. Which authority? What time? What date? Where is my lord?
No,
denied?
we will not go in those.
Yes,
My
my
No,
lord.
no, we will not go on those. We may not be very, very
It's
strict.
absolutely
We
premature,
are,
my lord.
we are on the substantial thing that whether you have actually gone to the authorities with a reply which was not affected, which was not accepted. There is
Right.
no environment
No,
also.
nothing, my lord.
My lord, there is no any written, my lord. I have to submit fairly before my lord, my lord. As I have inquired.
Then the order of this court and the submission of the standing council, state council have to be accepted. It is premature.
No, my lord, what we have, my lord, challenge in this petition is that, my lord, the land wherein we are residing, my lord, is purely a land allotted to us.
See, those are the
My lord.
going into the merits of the allegations made in the show cause notice.
My lord.
You reply, file your reply saying that these are incorrect
Absolutely.
allegations basis.
Absolutely.
And if they still go ahead, your doors are open.
Absolutely.
And my lord, may I pray for, my lord, closure or disposal of this petition, my lord, that as the notices is now time barred, my lord. And now we'll make an attempt to make the reply to them, those notices, my lord. Until the exercise is done, my lord, we may not be evicted, my lord.
We can give you 7 days time.
My lord, my lord,
7 days time.
my lord.
Okay. Heard. 3 A.R. Bhuya, learned counsel for the petitioners. Also heard 3 R. Borpujari, learned standing counsel revenue. 3 D. Gogoi, learned standing counsel forest. Full stop. 3 H. Sharma, learned additional senior advocate Assam, represents the other official respondents. Para? The grievance of the petitioners is with regard to apprehended eviction from the plot of land. Full stop. It has been projected that the land in question are revenue land,
My lord.
and in case of some pattas have
Lord,
even,
and land has also been allotted in our name. also.
but in
My-
case of some, pattas have also been granted. Full stop. The apprehension of the petitioner is that the eviction notices have been issued on an incorrect presumption that the land in question is forest land.
Forest land.
Full stop. Para. When this matter had come up for consideration on 11/8/2025, comma, Sri Sharma, the learned state council, had made a submission that the writ petition is prematured inasmuch as no show cause reply was submitted and therefore a final decision was yet to be taken. Full stop. The learned counsel for the petitioner at that stage had prayed for time with regard to the action taken for furnishing replies to the show cause notice. Para. Sri Bhuya, the learned counsel for the petitioners, by referring to the additional affidavit filed on 13/8/2025, has submitted that though the petitioners had approached the authorities with certain documents, those were not accepted. Para. Controverting the case of the petitioners, case projected by the petitioners, and also the statements made in the additional affidavit, comma, the learned counsel for the respondents have submitted that apart from that, there is no statement at all that the show cause notice were replied to, and a vague averment has been made in the additional affidavit that certain documents were presented which were not accepted. Full stop. It is also submitted that unless the show cause notice are replied, comma, the petition, the respondent authorities would not be in a position to consider the right of the petitioners, if any, which they may project against the action which has been contemplated. Para. At this stage, comma, Anand, in view of the aforesaid facts and circumstances, this court is of the opinion that unless the reply are submitted by the petitioners against the show cause notices, and further action is taken for not accepting the reply, no cause of action can be said to have arisen, enabling the petitioners to approach this court. Para. Accordingly, the writ petition is dismissed. Para. At this stage, Sri Bhuya, the learned counsel, has submitted that some time may be granted to enable the petitioners to file their replies to the show cause notice. Full stop. The said prayer has however been objected to by the learned counsel for the petitioners, as sufficient time has already elapsed since the time granted by the impugned show cause notices. Para. Be that as it may, in the interest of justice, further time of 7 days from today is granted to the petitioners to submit their show cause notice, submit their replies to the show cause notices, along with all supporting documents. Full stop. Till such submission, which has to be done within a period of 7 days, comma, no coercive action be taken. Full stop. It is however made clear that in case the replies are not submitted within the time specified, comma, the respondent authorities would have the liberty to go ahead with the not ahead, there will be no embargo on the respondent authorities in going ahead.
Lord, may I pray, Lord, instead of 7 days, can it be 10 days?
7 days.
Lord,
They already had the
many-
knowledge, my.
What is the date of the so-called notice?
My lord, it is long back, 7th of May.
7th of May.
May.
My lord, why I am taking extra 3 days, my lord? There are 180% are there. My lord. It may.
What
My lord, I-
7 days.
So
7 days, 7
from
days.
today, my lord.
7 days. We had given you a chance on the last occasion. You could have filed it. Matter would have been taken a different turn. 7 days.
7 days
My
from
lord,
today, my lord.
7 days from today. Okay, let it be 10 days from today.
10 days.
From today.
10 days from
From
today.
today,
Yes,
yes.
my lord, and with all respect, my lord, the authority will be the one who has issued the so
My
called.
lord.
My lord, the range officer, if lordship, maybe please to clarify, my lord.
Um,
The range forest.
It is needless to state that the replies are to be furnished to the authority which has issued the show cause
My
notice.
lord, my lord, my.
My lord, instead of dismiss, can it be disposed of?
No, my lord. There is
Yes,
no
ma'am.
further action. Where is the list, my lord?
Yes, next.
Obliged.
I'm
10
sorry.
days, 10 days করে দিবেন। আজ ইয়ে তো দিদি বা। We'll try to have this uploaded today itself.
My lord.
Because the reckoning will be from today.
My lord.
My lord.
Yes, next. Yes.
Both the cases, my lord, short question which will be rising before lordship is that the petitioner, he is in occupation of excess 2.28 lachas of land. 282 lachas of land, that your lordship will get it at page. Which one? 37, I'll come back. My lord,
There
I'll
are
just
two
put-
writ petitions.
Two writ
Which
petitions.
one would you like to have?
Both, my lord, if I place one back.
No, we have to relate to the pages. Which one would you like to refer now?
379.
379.
Yes. May I just place the facts?
Yes.
Hello, petitioner, he is a skill supporting staff. Now he is a retired from the agricultural, Indian Council of Agricultural Research. He retired in the year 2016. And 2088, my lord, he bought a plot of land, 1 kata 10 lacha. Lordship, just note that page 21.
Page?
21. On 1/10/2008.
You purchased the plot of land.
Land.
When did you purchase?
1/10/2008.
1/10/2008.
Measuring 1 kata 10 lacha.
1 katha 10 lecture.
10 lacha. Details are there at page 21.
Yes.
Then page 30, my lord, he purchased 7 lachas of land from the same owner on 21/5/2012.
7 lectures.
Yes.
Okay.
Then on 6/6/21, 2011, he sold a plot of land measuring 1 kata 2 lachas.
6/6?
2011, he sold
1 katha?
2 lachas.
To whom?
To one
Okay, then.
Buddha Gogoi.
Then.
Then, my lord, on 4/12/2012, building permission was granted. That is over a plot of land, 1 kata 10 lacha, that is admittedly wrong. That is wrong on his side in showing his land as 1 kata 10 lacha. After selling and all, it comes to about 15 lachas of land only. And spot verification was also made. There also they have found the petitioner is the owner of 1 kata 10 lachas of land. That was a mistake on the part of the petitioner in showing that he is the owner of 1 kata 10 lachas of land. And the spot verification, which was made by the authorities, that is also wrong because he did not have that plot of land. Now, Jamabandi copies, etc. are there. Now, Now, the complaint was made by the private persons. It is, they are not party here. my lord. Ultimately, my lord.
What is your cause of action?
We submitted a deed of agreement for the purchase of the 2.28 lakhs of land, which I am in occupation. We have purchased the 2.2, but that action was, they did not give permission. So therefore, we came before this honorable court. Honorable court directed to take appropriate action in the matter. And accordingly, my lord, notice was issued by the circle officer to the patterners seeking objection as regard sale of the land. That notice did not result in the patterners giving permission. So he was sitting over the matter. In the meantime, Jorhat Development Authority has given a notice of demolition of the excess portion of the land. So we came and filed a second case. In second case, the question is, my lord, the circle officer has issued notice. Circle officer has issued notice for the purpose of, from the patterners as regard, for the purpose of giving permission for sale of land. And thereafter he rejects it. And that rejection, my lord, he is not the authority as per the 2017 OM, because the authority is finally, my lord, the deputy commissioner. Your lordship will kindly see here in this case, page 99. Page 99. This was the notice issued. Taking objection from the patterners for the purpose of allowing permission to the petitioner for the purchase of 2.28 lakhs of land. Where he is in position and where he has built a house.
2.28
lakhs.
Okay.
So this notice was issued, my lord. Your lordship will kindly see page 86 first. 86, where the JDA first notice was issued at page 62 for demolition of a part of petitioner's land, page 62.
Yes.
Page 62.
Yes.
22nd July, 22nd
January.
January 2018.
That was the subject matter of an appeal. This court said that appeal has to be disposed of.
Disposed of, then
By an order of 28-2. Yes, those we have seen.
86, your lordship will kindly see, then there 86. Page 86, there was a 9th of the meeting.
Yes.
Private parties are also there, who are my neighbors.
Now, what is the position now? What is it? Neighbors have are agreeable.
There is a 145 proceeding is also.
Or they are not agreeable.
They are not agreeable.
Oh.
Ultimately, your lordship will kindly see that one page, 108.
Yes.
That red portion mark is 2.28 lakhs of land.
Yes.
Where the petitioner has built, he is in possession of the
No,
land.
there is no red here. It's all black and white.
Well, at size in my.
The one presented to the court is not colored. Doesn't matter which part.
Left hand side, 2.28 lakhs. There we have constructed the building consisting of 2.28 lakhs of land, which I am in possession from the owner.
Yes,
of the
now
land.
what do you suggest? How can it be reconstructed?
This can be suggested because the circle officer has rejected the permission on the ground that he did not get clearance from the patta holder. That is not the law. Other patta. That is not the law. Because first of all.
Okay, Mr. Das, you want to purchase this 2.28 lakhs from whom?
From the owner of the land.
They are not opposed to selling you. Okay.
There's an agreement to that.
Then how, what is the role of a neighbor in your purchase?
Role of the neighbor has got lot of
No, no, no. If you are purchasing a property,
for mutation.
those will be taken care of. But will the neighbor,
Has got no role, my lord.
no, no, neighbor has not, has
No
got
role.
no jurisdiction.
2.28.
If
acres of
the
land.
vendor has no problem,
Yes,
then what
that
should
is
be?
the law, my lord, your lordship, that is the only thing you are.
Then
not
your,
doing.
then your
In second case-
application for sale of 2.28 will be considered by the appropriate authority,
Deputy
Deputy Commissioner. And if a decision is taken in your favor, the demolition goes. If the decision is taken against you, you have the avenue to come to this court.
Yeah,
Come to this
appeal
court or
provision.
appeal.
But
Appeal before
2.28
whom?
to it.
Appeal before?
Before the Jorhat Development Authority only. 2.28 letters, there is an agreement for sale of the land. I am in occupation of the land.
That, yes,
and
madam,
for
you
a
are
very
for,
long time.
Lordship, I'm the neighbor. Lordship, in this matter, firstly, Lordship, there was a concealment of facts regarding.
Neighbor is
Martha-
one of the neighbor.
have you heard of Abu Ben Adem? You have not heard of Abu Ben Adem.
Neighbor is, my lord, he is an
You should love your neighbor.
employee of the Jorhat Development Authority, and his wife is an advocate. This man is in.
Yes, Mr. Goswami, from
Regarding
whom?
the house construction.
Definitely, apparent from the submission made by the Atlantic Senior College, there is a concealment because there is a rule. As per rule, they have to place the building permission. They have to provide the
No, Mr.
exact
Goswami,
area of his.
Mr. Goswami, we are not going to the legality of your action.
Uh,
What we are trying to resolve, the issue is that there is an application for grant of permission for sale of 2.28 lechas. Now, if this permission is granted and if the sale is executed, then the aspect of considering the construction which you have termed to be illegal can be taken afresh. Now, your contention perhaps is that this land over which the construction has been made is not owned by the petitioner. Now, if the petitioner gets a chance to have his.
My responsible submission of losses. And if this affidavit has been filed with the JDA, there clearly he was given ample opportunity. But your losses, can you look into the page Annexa S?
No,
There is
Mr.
the-
Goswami, what we are,
I'm kind, I understood, Malad.
We are not we are not against it. We are viewing this from another angle. His application for sale of land was considered by the circle officer and rejected. Who he says is not the proper authority. Let it be considered by the deputy commissioner. If it's rejected, you go ahead. If it's
No.
not rejected, he gets a chance to own this property and rectify the defects.
Malad.
We are not saying that your action is bad in law.
Malad.
Your action is as per law.
There is an office.
We are acted upon the.
Yes, yes,
The
that's-
circle officer's order, Malad.
Then who is for the
There is
state,
some that,
madam, your role. You will have a role.
Lordship has to decide in the.
Yes, let it be considered. But before that, we'd like to have your views on the contention advanced that it is the deputy commissioner who is the competent authority and not the circle officer.
That is the OM.
Are you, what is your take on this? No, there is an OM which has been placed on record.
Hello, there is an online and offline. Offline, your lordship will get it at second page.
Is under my lord right to public.
Yes. Come to 13, I think 13.
Yes. From 12, my lord. NOC can be applied offline also in the standard format.
From the deputy commissioner?
Yes.
Okay,
Ultimately, he is the deputy.
okay,
Circle of, and my lord, your lordship knows.
okay.
My lord, it-
Heard.
Reduce my.
It's here, my lord, only one aspect. My lord. the lordship knows, my lord, when notice is sent to the patadar, my lord, if the objection doesn't come, it is deemed that they have no objection. But circle officer saying that no, written objection, written no objection should be there from the patadar. No way, my lord. If the no objection comes, it is the permission. is there.
We'll say it will go in accordance with law. We'll only say about the authority.
Fine.
Both these writ petitions being filed by the same petitioner and connected, comma, those are being considered in an analogous hearing and disposed of by this common order, judgment and order. The facts projected is that the petitioner who had retired from service had purchased a plot of land measuring 1 katha 10 lecha covered by DAG number 9949 on 1/10/2008. Full stop. Thereafter, on 21/1/2012, he had purchased the adjacent plot measuring 7 lechas. Full stop. However, in between, the petitioner had sold a part of the land measuring 1 katha 2 lechas on 6/6/2011. Full stop. There is, however, a mistake committed by the petitioner while applying for the building permission, in which he had depicted the area of land as 1 katha 10 lechas, which should have been 18 lechas. 15 lechas.
15 lessons, sir.
15 lechas. Full stop. It also appears that the same mistake was overlooked in the spot verification, and accordingly, the petitioner had gone ahead with making the constructions. Full stop. Detecting the aforesaid irregularity, comma, the Jorhat Development Authority had issued demolition notice. Full stop. It is the case of the petitioner that he had made an application for purchase of land measuring 2.28 lechas, in which accompanied by an agreement, accompanied by an agreement to sale, in which notice was issued on 10/10/2018 by the circle officer to the patadars of the adjoining plots. Full stop. The grievance of the petitioner is that such consideration has to be made by the deputy commissioner under the present office memorandum dated 31/10/2017. And without doing so, the circle officer has rejected,
Denied the permission.
rejected the application by denying the permission.
17/12/18.
And accordingly,
The date is
the
17/12.
petitioner is apprehending demolition of the structure without even his application for purchase of the land in question being considered by the appropriate authority. Full stop. Para. I have heard Sri B.D. Das, Learned Senior Counsel for the petitioner, assisted by Sri H.K. Sharma. I have also heard Ms. M. Borman, Learned State Counsel, Sri Goswami for Sri U.K. Goswami for the Jorhat Development Authority, and Ms. A. Talukdar for
Respond number 5, Lordship.
response number 5. Para. The learned senior counsel for the petitioner has submitted that indeed a mistake had occurred while applying for the building permission, in which the description of the land, area of the land was stated to be 1 katha 10 lechas, which should have been shown as 15 lechas. Full stop. He, however, submits that in terms of the permission was granted. In terms of the permission granted after the spot verification, the construction was done, and to rectify the same, the petitioner has already entered into a deed of agreement to buy the plot, buy a plot of land, buy an area of land measuring 2.28 lechas, over which the portion of the constructions which has been termed to be illegal is situated. Full stop. He has submitted that the rejection of the permission by the circle officer is without any authority of law, as the office memorandum dated 21/10/2017 holding the field contemplates the authority to be the deputy district commissioner. Full stop. Para. 3. Goswami, the learned counsel for the Jorhat Development Authority, has however submitted that all actions taken for demolition are strictly in accordance with law, as the construction has been made on an area which is not owned by the petitioner. Full stop. Ms. Talukdar, the learned counsel for the response number 5, has also supported the objection, has supported the views and as views expressed by the learned counsel for the Jorhat Development Authority, and has submitted that the construction being unauthorized, the same should be demolished. Ms. Burman, the learned state counsel, has however not disputed the position that as per the office memorandum dated 31/10/2007, the designated authority to take a decision on the aspect of sale of land is the district commissioner. Para. After hearing the learned counsel for the parties, this court is of the opinion that unless a decision is taken by the appropriate authority on the application for purchase of land made by the petitioner for 2.28 lechas, unless a decision is taken for purchase by the competent authority, namely the district commissioner, the action of the Jorhat Development Authority to demolish the structure in question is required to be kept in abeyance, which would serve the interest of justice. This court is also of the opinion that in the event the competent authority, namely the deputy commissioner, rejects the application for purchase of the aforesaid area of 2.28 lechas, the Jorhat Development Authority would have the liberty to go ahead with their action for demolition of the unauthorized structure, but till such a decision is taken by the said authority, the proposed action may not be, is not required to be, may not be gone ahead with, full stop. It is also clarified that in case the petitioner is aggrieved by any decision taken by the appropriate authority, namely the district commissioner, by which the petitioner may be aggrieved, he would have the liberty to challenge such decision, which however has to be done strictly in accordance with law, full stop. Para, since the matters are pending since long, the petitioner is directed to submit a fresh application before the district commissioner, Jorhat, within a period of 3 weeks from today. And on submission of such application, the same is to be considered expeditiously and strictly in accordance with law. And the decisions taken be conveyed to the petitioner within, preferably within a period of 45 days from the date of submission of such application. Both the writ petition stands disposed of.
45 days may not be, because they will have to give notice to the pata holder. So
We have said preferably.
2 months.
2 months, 60 days, 2 months.
Obliged.
Yes,
Please,
naturally.
my lord. Lordship, the petitioners in item 15.
PWD? PWD, anyone? Please inform PWD. And there is one unlisted syndicate. I put it to last into heavy work. You come at 2 o'clock and bring the PW. There is one listed. If it comes, we'll take it up. Otherwise, unlisted will go up to Monday. So, open official council, unlisted. Okay. Your matters have not come, Mr. Kaushik. No, we said we'd have to rise early. Okay, we'll try at 2 o'clock. But that will be the only item which will take up.
Yes.
Okay. And try to get my PWD.
Yes.
Yes.
May it please your lordship. My lord, in this matter, what has happened is the petitioner is a hotel, namely Borel View Agency. Now, my lord, EPFO, Employment Provident Fund Organization, has raised a demand on some another private limited company, namely Borel View, Mrs. Borel View. Now they have raised a demand against Borel View, and subsequently, my lord, the property in which the Borel View, Mrs. Borel View were conducting their business, I have purchased that only property, my lord. I purchased that property. Now, my lord, my one is a partnership firm. They have raised a demand that Mrs. Borel View and Mrs. Borel View Agency, that they the organization department got maybe a confused, my lord, that both the firms are same. And if your lordship may look upon the order dated 29th April, which has been challenged at page number 45, my lord.
You are a company or you are a firm?
I am a partnership firm.
Who are the partners?
My lord.
Who are the partners?
There are 5 partners, my lord.
Who are them?
My lord, I have annexed the partnership deed at page number 27, my lord.
27.
Annexure 1.
Yes.
There are namely 5 partners, my lord. Nilesh Kumar Agarwal.
And the other one?
Is a
Borel View?
Private limited company, my lord. The PAN cards are different. Both the entities are distinct. They do not have
No,
any.
Borel View is a company.
Is owned by a private limited company, namely
Croziers.
Yes, my lord.
Well, let us see the board of directors of Croziers.
My lord, the board of my lord, the board of director list of board of director is not furnished, my lord, but the partners in this firm and the board of directors of that particular company or equity holder, none of them are same. The partners have no relation. We have purchased the property by way of a deed of convenience, my lord. The deed of convenience I have annexed, my lord, at page number 47,
But if you come to page 48,
my lord.
you come to page 48,
My
the
lord.
date of conveyance,
My lord.
it's, see, Borail View Residency, this is, the View Residency is yours.
My lord. If your lordship may look.
Now, what
upon-
about the assets and liabilities that we purchase?
My lord, I have only purchased the property. I have not purchased the company. I have no relation with the company. I have only purchased the
Mr.
property.
Akhtar, what do you say?
Your Lordship, in this case, instead of filing this writ petition, they could have first given representation to the respondent number 2. If their claim is this, without going to giving a representation.
Who is respondent number 2?
Who has attached the freeze the account?
EPNP.
Assistant Provident Fund Commissioner.
My lord, day after yesterday, my bank accounts were freezed.
Yes,
You appear for the bank.
I am for the bank. We have just complied the order of the respondent number 2.
I think PF has a standing counsel, EPF.
My lord, we have served the copy to the government advocate and also to the
No,
concerned.
EPF has a standing counsel, I think. EPF for কোন P Roy নাকি? PK Roy. PK Roy, Nandi or ADAS. ADAS no, ADAS is বেলেগ. I think there is a standing counsel.
My lord, we.
Either Mr. Nandi or Mr. PK Roy.
If your lordship may look upon the interim order, my lord, here it is written Mrs. Borel View alias Mrs. Borel View Agency, my lord.
Not agency, Regency.
Regency, my lord. Apologies. Regency. And in fact, my lord, the first demand that is on 29th April was issued only to Mrs. Borel View, not to me, my lord.
No, Mr. Athi, there is no problem in issuing notice, but at the same time, you have an interim prayer for defreezing the bank account.
My lord.
Whether that can be done on ex parte, this will amount to almost the final relief.
My lord, the authorities.
45 lakhs.
My lord, my property worth is 10 crore. The authorities have the power to attach my property also. They can duly exercise that power.
When was this done? The freezing?
On 12th, my lord, the day before yesterday.
This law, standing council sign a forward EPF. I think EPF. I think there is a standing council. We can do one thing. We can have this matter on Monday. Let there be an effective order. You serve upon either Mr. KK Nandi is there or PK Roy. Mr. Sharma? EPF. EPF, I think Nandi or PK Roy.
Offending counsel. Most probably Nandi, but even then, Lordship, I'm not that
I've
sure.
repeatedly, my lord, consulted in the bar regarding if there, however, I was unable to come to any.
Has somebody suggested about PK Roy or Nandi, KK Nandi?
No, my lord.
I think these are the.
Reason which I served it to government advocate Assam and.
No, government advocate will not be able to help you. This is EPF is a different entity altogether.
My lord.
We'll have this on Monday.
My lord, if interim protection till Monday may be granted, my lord, my
What
entire
kind of
operation, entire operation is based on.
What
this.
kind of interim? Tell us. We
My
cannot.
bank may
That
be
is the
till
reason. we
Monday,
have-
my lord. If so required, court may vacate the interim, my lord, because my entire 100 employees are working in my partner in my.
2 days you have to wait. For defreezing, it's not a kind of a stay. It's a mandatory kind of injunction
Yes.
to defreeze.
My lord.
Had it been a matter of suspending something, it's okay. But this is a positive mandatory injunction. That defreezing, that means you have to be, the bank account would be operative. Just wait till Monday. Heard, Sri Learned Council for the petitioner who has put to challenge the action of the respondent number 2, Estate Provident Fund Commissioner in imposing a penalty as well as the action of defreezing the bank account maintained with the Punjab National Bank. Full stop. It is submitted that that perhaps due to certain mistaken notion regarding the entity involved, such impugned action has been taken. Para 3. A. Parvez, learned counsel appearing for the PNB, has submitted that the action by the bank has been taken pursuant to the directions made by the respondent number 2, so and so assistant. Para. Let this matter be listed for motion on Monday, by which time the learned counsel for the petitioner would try to serve copy of the writ petition to the counsel who normally appears for the EPF. Full stop. List accordingly.
Much obliged.
KK Nandi or PK Roy? Both of them sits in the first or second table in the bar.
Much obliged. Meet later. Here the petitioners, my lord. These are the residents of villages, my lord, which falls within the borders of Assam and Arunachal. My lord.
Okay.
And pursuant to the Namsai declaration that was between the Arunachal and the Assam, the notification were issued by both these states, and committees were formed to identify the villages which falls within the Assam and Arunachal. Now these committees were constituted, and there are terms which is mentioned in the notification saying interaction with the villages, with the civil society and the other headmen, and the
You fall where?
Malod,
According to you?
according to us, we fall within the state of Assam.
Okay.
And in fact, my lord, Assam in the meantime, as the resolution of dispute is going on, in the meantime, Assam has issued 2 notifications saying that the person who are staying in Arunachal but has a link to the Assam, ancestors are Assam, and they have a permanent structure, they are being asked to apply for permanent residential certificate also.
Okay.
So this dispute is
Now
still
your domicile is Assam.
Assam,
And you are staying in the territorial boundaries of Assam.
territorial boundaries.
Now, who has issued the notice?
The notice has been issued by the Arunachal Pradesh, the Forest of Range.
Yes, Mr.
Lordship,
Chandan.
I have to take instruction, Lordship, in this matter, Lordship. Because the notice was issued on 19th of July.
Okay, yes.
And
Heard Shri B. Kaushik, learned counsel for the petitioners who are aggrieved by eviction notices dated 19/7/2025 issued by the
Manabhum Forest Range, Lathao.
by the
Page
Range
25.
Forest Officer, Manabhum Forest Range, Lathao, Arunachal Pradesh. Full stop. It is the contention of the petitioners that a boundary dispute is being resolved, and it is projected that the petitioner who are domiciled of the state of Assam are being served with notice by an authority of the state of Arunachal Pradesh, which is without jurisdiction. Let notice be issued, returnable by 4 weeks. Sri H. Sharma, learned additional senior advocate 1 and 2. 1, 2 and 4. 1, 2 and 4. 3 and 5 by H and 1, 3 and 4. 1 and
1, 3 and 4.
not 3.
No,
Not
1 and
3.
4.
1 and
4.
not 4. 4 is Arunachal.
Only 1.
Only 1.
No,
Only
4
one.
is Tinsukia district, my lord. Regional committee, that is the committee.
4 is Tinsukia.
Okay.
Tinsukia.
1 and 4. And then 2, 3 and 5. H and
Lordship.
Sri Kaushik, learned counsel praised for an interim order, para. Considering the facts and circumstances, comma, till the returnable date. The eviction notices dated 19/7/2025, qua the petitioners are not to be given effect to. Para. The interim order having passed at the motion stage without instructions, comma, the same would be reconsidered on the returnable date.
Yes.
First of all, let the returnable date be fixed on. We'll have it on 1st of September,
Lordship, grateful, man.
2 weeks time.
Highly-
Get the instructions.
Much obliged, Lordship. Good.
Yes.
Yeah, definitely.
You were supposed to inform somebody PWD. Yes, Mr. Bhuya,
Yes, yes,
PWD.
yes, Lord.
Yes. What do you say?
Lordship, per my understanding, based on the last order, the government was supposed to bring instructions regarding whether there is any, how to compensate.
Yes, the notification was actually issued by the government.
Lordship.
The notification, if Lordship looks at the
Mr.
affidavit.
Sharma, your colleague, Mr. N. Goswami, was
Yes, Lordship, those instruction we have not received, but after going through the writ petition, Lordship, it's under the Assam Mala. It's a direct purchase through negotiations.
yes.
Had it been a case that we have acquired the land under the Land Acquisition Act 1894 or 1964, Lordship, the matter would have been different. In that case, Lordship, we have to go by that fair compensation 2013.
Now this is a case of direct purchase.
Direct purchase, it's a negotiation. It is not like that we have to purchase it as per the terms and conditions of 2013. It may be higher or it may be lesser. So accordingly, Lordship, we are not binding by that act of 2013 in this direct purchase.
What is your claim, Mr.
Yes,
Chaudhary?
so my claim, Lordship, is that we had some pakka shops in the this
Government
Pa-
land.
in Panchayat compound, Gao Panchayat compound, in this Silburi Gao Panchayat, we had some pakka shops. And thereafter, there was a road and for which there was widening of the road under this scheme. And for that, we were given assurances that will be compensated for the loss that has occurred. But ultimately, nothing was done. And thereafter, we approached. And their stand in the affidavit is that factually, they have not opposed. They are saying that, yes, your pakka shops were broken, but because it was not on patta land, therefore, there is no question of giving any compensation. So that is their stand. So, Lordship, in that, if that is the stand, so therefore only the legal point remains. Factual part is done. So they in their reply affidavit or opposition affidavit, they have annexed the notification in page 114.
114.
114.
Yes.
And in under that notification, they say these things were acquired, these lands were acquired.
Yes. Direct purchase, yes.
Direct purchase. So page 115, Lordship, I would like to point out one thing.
Yes.
That in paragraph number 3,
Yes.
Assam Mala being a flagship program of Government of Assam calls for expeditious acquisition of land for speedy implementation of the program.
Yes.
Section 46(1) of the ultimately they say that nothing is to be done, but here they have mentioned this Fair Compensation Act.
Yes.
Has been considered for direct purchase.
Yes.
So if this is the stand, so they cannot get away from this stand. So if that is so, so once
Sorry, Lordship, we have been directed to obtain the instructions. We have not yet received any instructions.
No, but
Should we-
Mr.
should we
Chaudhary,
wait
what
for-
is your right?
so that's what I.
If your establishment of shops
Yes.
is on government land,
Yes.
which you have utilized for a long period of time,
Yes.
for demolition of the same, what is your right?
My right. So
And
the-
this
yeah.
notification
Yes.
has been issued taking into consideration the Fair Compensation Act of 2013.
Yes.
It doesn't say that, we will again go back to the Fair Compensation Act. That has been taken into consideration before issuance of this notice. Your right is based on, your claim is based on which right?
My claim is based on because the 2013 Act does not only compensate landowners, they also compensate, they have a term called as affected
Yes.
families.
Yes.
So we fall under affected families. If this was our primary source of income for the last 3 years, We are affected.
No,
family.
affected family, if you are encroacher,
So we are not encroacher because we were within the panchayat compound. We have been given license to run and under Rule 18, we were not evicted. Had we been evicted under Rule 18, that we are encroachers or something, that's a different issue.
no, we are not adjudicating a lease where eviction is the subject. We are trying to adjudicate a claim for compensation
Yes.
by a person who alleges that he has suffered damage because of demolition of his shop.
Yes,
Now, his shop is not on a patta land.
not on a patta. Yeah.
So this area in question, while it was required for the expansion of the project,
Right.
this was required by means of direct purchase from whom?
Now, Lordship.
No,
if,
this was required from
yes.
direct purchase from
So,
whom,
I
Mr.
would-
Sharma?
From the landowners, Lord.
No, this is not, this is government land.
No, it's a government land.
Then,
It's a government land. They are constructing their rooms there and doing the
No,
business.
actually,
now
the-
this, while utilizing this land for the Assam Mala,
Yes.
how do you acquire, what is the process?
No, that is the procedure, Lordship. We make an offer to the landowners.
No, here there is no landowner.
As because they are occupying the government lands, so the question of
That is what, if it is a government land, is it again required to pay somebody?
no, Lordship, no.
Then-
Under that notification of 21, where the direct purchase that Assam Mala is there is no such provision.
now,
In case of acquisition, in case of requisition and acquisition, in that case, Lordship, 2013 Act will apply.
now,
But this is a negotiated procedure,
now,
Lordship.
Lordship, within 5 minutes, I will just show 2-3 provisions. Thereafter, Lordship will take Lordship's view.
Yes,
If Lordship takes up this act for just maximum 5 minutes, I think.
yes. Here is on 13 Act, 2013 Act, is a fair compensation. Right to fair compensation. Yes.
So, Lordship, here I am referring to the section which they have referred in the notification, section 46.
Yes.
So this is relating to direct purchase, section 46. And here the government is taking the land. If government is taking the land, is using section 46, then that means that they are not the specified person. Section 46. So if it is section 46, so subsection 2, that it is the duty of the collector to refer the matter to the commissioner for satisfaction of all the relevant provision under this act related to rehabilitation and resettlement. So only so far as rehabilitation and resettlement, we can be covered. We cannot be covered under Schedule 1, which talks about giving the fair compensation for the acquired land, because it's not patta land. But so far as rehabilitation and resettlement, that is in Schedule 2 of this. So here, Lordship will see subsection 2, then subsection 3, 4, and 5. So even if there is direct purchase, there is question of rehabilitation and resettlement. And this is for whom I would now like to show section 3C. Section 3, this is subsection C and clause 2, Roman 2. So this is the definition of affected family.
Yes.
Our family, now I am coming to last 3 lines because or, 2, 3 types are there. I am coming to last 3 lines, or who may be working in the affected area for 3 years prior to the acquisition of land, whose primary source of livelihood stand affected by the acquisition of land. So if this last 3 lines of clause Roman 2 is taken, then we fall under affected family. And if that is so, And what I'm asking is not too much also, because that is in schedule 2. It's a very small amount actually. Schedule 2, if lordship comes.
Please read the entire subclause
Yes,
2.
subclause
A
2.
family.
A family which does not own any land, but member or members of such family may be agricultural laborers, tenants, including any form of tenancy or holding of usufruct right, sharecroppers or artisans, or who may be working in the affected area for 3 years prior to the acquisition of land, whose primary source of livelihood stand affected by acquisition of the land. Few categories are mentioned.
Yes.
But an or is mentioned. It is not that I have to fill all the checklist.
What is the affected area? Means the area notified by the
Notified
government.
the appropriate government for purpose of land acquisition.
Yes.
So this is, of course, they have admitted this is the area. Within from Dolgao to Fotasimolu, this whole land, road was widened, and many patta lands were also taken. They have got the compensation. That
Now
is
we
all.
want to know the status of the, with regard to the status, which is government land.
Yes.
From that angle, we want to.
From that angle, lordship, schedule 2, if lordship sees, schedule 2 to this act.
Schedule 2.
Yes. First schedule is, lordship, compensation for landowners.
So we are at schedule 2.
Yes. First schedule is compensation for landowners. We don't fall under that. We are not landowners. Now, schedule 2, there is second schedule, that is elements of rehabilitation and resettlement entitlements for all affected families, both landowners and families whose livelihood is primarily dependent on the land acquired. So I am saying my minimal rights somehow comes from this. Here, number 8, in schedule 2, serial number 8, if lordship says, serial number 8, a very minimum compensation is there.
Yes.
One-time grant to artisan, small traders and certain others. So I am a small trader. So here, each affected family of artisan, small trader or self-employed person or an affected family who own non-agricultural land or commercial, industrial or institutional structure in affected area and which has been involuntarily displaced from affected area due to land acquisition shall get one-time financial assistance of such amount as the appropriate government may by notification specify, subject to minimum of 25,000. So this is the minimum right. Somehow I have found out that this is one way and maybe a right exists. Yeah, if a combined reading of section 3C, 46, various clauses and schedule 2. So that is my humble submission.
Yes, Mr. Sharma.
Yes, lordship.
Now see, the second schedule of this 2013 Act, it is not only aspect of compensation for the landowners, it is compensation for rehabilitation and resettlement of persons who do not own the land.
Yes.
Now, there may be several categories of persons who do not own the land. Suppose a tenant.
Lordship.
But tenant has to be related to a landlord who owns the land.
Lordship.
Now, here we are in a situation where the land is, there is no owner of the land as such.
Lordship.
It is government land.
Lordship.
So what will be the situation?
Lordship.
That is what.
Now this act comes, lordship. Your lordship may kindly come to the introduction part.
Yes.
Introduction part, lordship. Statement of objects and reasons. Has your lordship got?
Yes.
The Land Acquisition Act 1894 is the general law relating to the acquisition of land for public purposes and also for companies and for determining the amount of compensation to be made on account of such acquisition. The provisions of said act have been found to be inadequate in addressing certain issues related to the exercise of the statutory powers of the state for involuntary acquisition of private land and property. The act doesn't address the issues of rehabilitation and resettlement of the affected persons and their families. So this act comes because of all those inadequacy in the Land Acquisition Act of
No, the
1894.
basic question will still arise. Are you required to acquire government land?
No. No, lordship. As
If
because,
there is
no, under this act, they are entitled for zero compensation. But this is a direct purchase. It's an agreement between the parties. We may not go to the amount which is fixed there. We may say that, yes, you are entitled for 50,000. If it is agreed upon, we cannot retreat from that.
This agreement was with whom?
As because there in a government
was
landlordship,
it
there
who-
is no such agreement. As because under that Assam Mala, there is no such provision for, this provision is not incorporated there. So we have agreement with the persons who have got title over the plot of land, the landowners. Accordingly,
That is what the question is. If it's a land owned by the government, there is no question of
Yes.
acquiring a government land.
yes, Lord, as because they are constructing houses there, we have demolished that and eviction was done and lordship, that Pakka road was constructed over there.
The houses, dukan
Yes, yeah, no.
Now the land, the expression land which you are referring,
Yes.
will it be land which can be also government land?
Yes, in our affidavit, lordship, we have specifically mentioned, they are also not denying that.
Lordship, if something, I think for government land, there is no notification required. Anything where no patta is there, it is government.
Government land.
That's why there is no such agreement with
There
them.
cannot be any question of acquiring government land.
Yes,
It is the
yes.
government's own land. Why should
Yes.
they acquire?
That is true.
Acquisition would be done only when the land is owned by somebody else
Yes,
or somebody's rights are affected.
yes,
You say that your rights are affected.
right.
Your rights are affected over which land? Land owned by the government,
Government.
not by somebody else.
Yes, Lord. Had it been a
Let
case
it be
that
on
they
a
are patta holders.
tenant or a riotee or anyone who's affected. So there is a catch there. Okay, Mr. Sharma, I think we need to have some more input
Lordship,
from you.
lordship.
We have understood your verdict. You said that everything has been taken into consideration. It's a direct purchase,
Yes.
wherein even these aspects of rehabilitation, resettlement are also included in the
Yes.
purchase price.
For instance, one plot of land, the amount is, the value is 1,000 only. We have agreed that we are going to pay you 1 lakh. We must have to pay. We cannot retreat from that 1 lakh. As because it's a negotiated settlement.
No.
Agreement,
So the question which, the instructions which you are required to take is that for the land for which the present two cases are pending, are those lands part of the direct purchase? If it is, with whom did you negotiate? Whom did you pay? That will come only when there is an owner.
yes.
If it is government land,
None
if
of
you
the
can show,
petitioners are the owners of the plot of land.
they may not be. But if somebody else is also the owner, they can have some right of
Yes,
rehabilitation.
yes.
But is this land owned by somebody or was it khas land?
Khasla, in our affidavit, we have stated, lordship, the affidavit
And
is
then
here.
scope will be very less.
We have
to stretch.
specifically mentioned.
The question of rehabilitation resettlement may come.
Lordship, if this act, I have shown that it goes beyond landowner. In Assam, landowners mean patta holder. There is no absolute landowner as such. So if
No, that
we
is
are
what we are saying. Landowner does not, your rights can still be there if you are a tenant of a landowner. You are not a landowner. You are a tenant. You are a riotee. You are a sharecropper. But
That-
your livelihood is dependent on certain portions of land owned by Mr. A. But this land pertaining to this case is owned by none. It is
But-
government land.
That is why there is no such any agreement with them. Had it been a case that they are the landowners who make payments lesser than the agreed amount, in that case, yes, lordship.
Okay. Heard 3, H.K. Chaudhary.
Yes, Lordship.
Learned counsel for the petitioners. Also heard 3 H. Sharma, learned state counsel, as well as 3 B. Gogoi, learned standing counsel PWD, Para. On the prayer of 3 Sharma, the learned state counsel, matter is adjourned by 2 weeks to enable him to take specific instructions on the aspect of the status of the land in question.
But that is already,
And-
but
huh?
within that, that is already
And-
reflected in our affidavit. It was not mentioned on the earlier date, most probably because of the lacking on our part. That is why that order was.
No,
passed.
no,
But
no,
it-
no,
Lordship,
2 weeks.
pardoned or
No,
may
2
fix
weeks
it for
to take further instruction, only, to take further instruction.
Lordship,
But this is what we need from both of you.
Lordship.
You may still make out a case.
Yes,
whether
I'll
in-
try because otherwise.
Even if
it's
it is a
very-
government land,
Yes.
then also you are entitled to something.
Yes.
But the
But,
stumbling block in your submission would be government if it is government land, there is no question of acquiring.
But Lordship.
If there
this-
is no acquiring,
But-
then there is no question of payment.
In case of acquisition, Lordship, for instance, in this case, Lordship, Assam Mala, if somebody refuses with the negotiation, in that case, we have to adopt that.
For 30,
Yes,
20
yes, Lord.
30 I mean,
In that case, they are entitled to.
because direct purchase
Lordship
is
is keeping it part.
direct purchase is a negotiated
Lordship.
purchase.
Lordship.
If somebody is not willing, it will not be a negotiated purchase. Then
Lordship.
you have to abide by 2013.
Lordship.
Okay.
Much obliged.
Obliged.